With the consent of the other side as well, can matter be taken?
You are 4D?
Of my
A prayer is made on behalf of Mr. A. Goel, learned counsel for the petitioner for an adjournment in the matter on account of person. Have you taken the consent?
yes, sir.
Prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this matter again after the ensuing winter vacations on a date to be fixed by.
My lord, I want just adjustment, my lord. Item 1527. Maybe taken a bit later, my lord, because I've got one partner matter, my lord. 2013 matter.
We had asked for some instructions from the.
Yes.
Was the financial bit submitted? That is why. Then why have you made that statement in the petition, in the affidavit that he has not submitted? Mr. R.P. Sharma, learned counsel for the petitioner, submits that. When do you want it?
Today itself.
Today itself.
Yes.
Then
Just
accommodation, no
yes.
problem.
my lord.
No problem. You take your time.
Yes.
32. The consent. And I pray on behalf of the state. Yes, you've got the instructions yesterday. I'll have to.
First returnable
I-
date.
Yes, I am appearing for the petitioner in this case, sir.
Mr. B. Gogoi, learned additional advocate general, submits that the instructions in the matter has been filing his affidavit within the next 4 weeks. Mr. D. Das, learned senior counsel, appearing for the petitioner, does not object to this said prayer. Registry to list this matter after 4 weeks on a date to be fixed by it. Any interim order?
Interim order is.
Interim order passed earlier to continue till the next date of listening.
My lord, only one request.
One date may be given after the BU. File it, madam.
Yes, Mr. Das.
One request is there that the court will allow us to file an application for implement. Nowadays, you cannot correct also. I think that's a, so because we have to add one party, Assistant Commissioner. Commissioner.
There is no problem. There is
Yes,
no
that's
bar.
why I thought that I will just. Yes.
Meeting, we can have no objection. Registry to list this matter again
22nd
on 4 weeks now, like 22nd.
January.
Das, comfortable?
22nd is. Deeply obliged.
Monsoon doesn't set that. 8:29. Paying for a week time for you.
Have you taken the consent?
Yes, Lord.
You are for?
One in item number 20.
Mr. M. Smith, learned counsel for the petitioner, for the respond number 6, had circulated a mentioned memo for an adjournment in the matter on the ground that the arguing counsel is not present today on account of certain engagements. Also, accordingly, he prays that the matter be taken up after the ensuing vacations. Prayer is not objected to by the opponents. Accordingly, registry to list this matter again on when?
On 5th.
5th will be too early. Opening only. Let us have it on 8th. Yes, madam.
May it please your lordship. Lordship, with the consent of the other party, I beg to mention item number 4, lordship. Seek for an adjournment in this matter due to personal inconvenience.
Has the prosthetics been fitted?
Yes, lordship, and it is working fine.
A prayer is made on, a prayer is made on behalf of Mr.
P. Mohanta, lordship.
P. Mohanto, learned counsel for the petitioner for an adjournment in the matter on account of certain personal inconvenience. Prayer is not objected to by the learned counsel. Accordingly, registry to list after the institutions on a date to be fixed by.
Grateful, lordship.
Yes.
May it please your lordship.
Yes, madam, anything?
My lord, this is regarding repudiation of an insurance claim which eventually traveled to the permanent Lok Adalat. And against the order of the permanent Lok Adalat, we are before your lordship. But to place the facts, I may just point
First
out,
and foremost, whether this order can be challenged in a writ petition.
my lordships.
When there is no allegation that the same was passed without any, that it is a fraud, something
Madam,
initiating.
But if lordship permits me, lord, 2012, 8 SCC 243. Mm,
2012,
Volume 8, Supreme Court cases 243. I would be referring to paragraph 38.
what does it say?
May I read that, my lord?
What is the name of the party?
Bar Council of,
Oh,
Bar Council of India versus Union of India.
what does it say?
There is no inherent right of appeal. Appeal is always a creature of statute, and if no appeal is provided to an aggrieved party in a particular statute, that itself may not render the statute unconstitutional. Section 22E1 makes every award of the permanent Lok Adalat under the 1987 Act either on merit or in terms of a final settlement and binding on all parties thereto, and on persons claiming under them. No appeal is provided from the award passed by the permanent Lok Adalat, but that in our opinion does not render the impugned provisions unconstitutional. In the first place, having regard to the nature of dispute up to a specific pecuniary limit relating to the utility service and resolution of such dispute by the procedure provided under sections 22C1 to 22C8, it is important that such dispute is brought to an end at the earliest and it is not prolonged unnecessarily. Secondly, and more importantly, if at all, a party to the dispute has a grievance against the award of the permanent Lok Adalat, it can always approach the High Court under its supervisory and extraordinary jurisdiction under Articles 226 and 227 of the Constitution of India.
That can be under 227.
No, and 226 and
But
227.
you have come only under 226.
No, I can come on the
Or,
226.
it is not or, it is and.
It says,
Supervisory jurisdiction would come under, it's a form of a decree, basically.
I absolutely follow what my lordships
So
has said.
227.
What this judgment says is that we can come approach the High Court under its supervisory and extraordinary jurisdiction under Articles 226 and 227. If that is an mandatory
Okay.
to have 226 and 227, I may read into that. But that's not the
This is
issue.
one prelim.
One phrase. Second,
Second one.
without going into the evidence and merits of the cross claims and counterclaims, one aspect, I'm being absolutely fair to the court, if lordship looks into whether they could have repudiated in terms of the law, whether there's a bar of limitation capped.
This is before 2014 or after 2000?
Repetition 2014,
No.
repudiation 2008.
The claim is of
Claim is earlier, my lord.
2005. That
Fine.
is before amendment of the 2000 section 45. 2-year bar.
2-year bar. So if we
Whether
take,
that is an absolute.
I'm not on that. May I read 45? Then we'll go on merits.
Insurance Act.
I thought it would be relevant to point out, my lord. It would hit on the root. Amendment from right. May I read, my lord? No policy of life insurance effected before the commencement of this act shall, after expiry of 2 years from the date of commencement of this act, and no policy of life insurance effected after the coming into force of this act shall, after expiry of 2 years from the date on which it was effected, be called in question by an insurer on the ground that a statement made in the proposal for insurance or in any report of a medical officer or referee or friend of the insured or in any other document leading to the issue of the policy was inaccurate or false, unless the insurer shows that such statement was on a material matter or suppressed facts which it was material to disclose, and that it was fraudulently made by the policyholder, and that policyholder knew at the time of making that statement was false, or that it was suppressed facts which it was material to disclose, provided that nothing in this section shall prevent the insurer from calling for proof of age at any time if is entitled to, and no policy shall be deemed to be in question merely because the terms of the policy adjusted on the subsequent proof that the age of the life insured was incorrectly stated in the proposal.
Hmm.
Now, my lordships, to apply the proposition or the law as mandated under section 45, there will be two parts, my lord. The first, the dates, and the second, the judgment, how it was dealt with.
Yes.
My lord, if my lord may have the list of dates for a moment,
This last part
my
of
lordship,
this, how do you deal with that?
fraudulent part.
Not fraudulent part, non-disclosure of all relevant materials which were there. to your-
That's why I said, first, the dates, and the second, the judgment, how it was dealt with.
Oh, fine.
Therefore, I'm reading the judgment, my lord.
Come to the judgment.
No, I have to read the judgment. Whether it was a non-disclosure per se, that is what, how the honorable, then the tribunal,
See,
look at what they dealt with.
Not the question of non-disclosure per se of the fitting of the pacemaker. It is the reason why the pacemaker was fitted. That means you had a subsisting pre-existing heart ailment and you died of a heart attack.
But I may
These
say,
are two facts, I
I may
think.
say something which is from personal experience. Since my father had implanted, it is not related with the case. So these variations may occur sudden and prompt.
I'm not on
It,
that.
it has nothing to do
I'm
with the
not
heart
on
ailment.
that is not an issue also.
Sure.
That is not an issue. The issue was whether you had an heart ailment and you knew about it and you disclosed it.
Therefore, I would read
We'll
the.
go there.
I understand.
But say you have an heart ailment. In the appraisal form, the form that is
Yeah.
there, there are certain questions asked. These are not without any basis.
Correct.
This is for the insurer
Correct.
to assess whether he will undertake the insurance policy or
Absolutely.
he will not, or he will ask for a higher premium.
Absolutely.
Now, if he is prevented from doing that,
Right.
then the
It goes
last
against
part,
it.
that last part would come
Absolutely.
into operation.
Correct. You come,
Now you can take me.
my lordship.
And you have already taken back the premium amounts
Right.
with 9% increase.
Whatever paid. Paid. Yes, yes, yes.
And that was not disclosed in the writ petition because it happened on the same day.
Perhaps I do not make long back now, my lord. That I do not think. That once they.
You
walk
have
in-
filed an affidavit.
Yes, yes, I've seen that.
You have not filed a reply to.
No reply.
Fine. What is it now you want to say?
May I read the award first? Page 23.
Hmm.
I'll go slow, man.
Page
23,
of the,
writ petition. Because that is the sum and substance of everything.
you may not take the trouble of going through the whole thing and come to the conclusions. Page 25 onwards. Till 25 first paragraph.
No,
It is.
I would go to page 24, the last paragraph, second last paragraph,
Okay.
if Lordship permits me.
Hmm.
We have heard.
Hmm.
May I read?
Hmm.
We have heard the argument advanced by learned advocates of both the parties and minutely scrutinized the materials available on record. Sri Ranjan Roy, a learned advocate for the petitioners, have vehemently argued that the opposite parties cannot brush aside the certificates of its own doctors and repudiate the claim. More so, when DW1 himself admitted the requirements of special medical checkup if the age of the proposed assured is 59 years like the deceased. Therefore, had permanent pacemaker been implanted on the deceased, it would have been certainly detected on his medical checkup carried out by the empaneled doctors of LIC at the time of obtaining the policy and at the time of its revival, and on both occasions the health condition was certified as good, and so the allegations of implantation of permanent pacemaker by Dr. P.C. Sharma on 26/2021 at KC Nursing Home Silchar is false. My first contention, Milo. On both occasions, your doctors had assessed me clinically.
Now come to that assessment.
I'm come to that. He objected to the
Just a moment, just come to that assessment. It is available in your, it is available in that policy somewhere. Found it. There is that.
policy copy as well.
That policy form.
Policy हम तो किन्हीं बोला था ना? No. Exhibit से था. Exhibit से हम तो बोला.
Page 43
Do sir. 43 command.
of your, that running page 43 of this affidavit.
Oh, affidavit.
Affidavit 16.
Page 16.
अच्छा, एडी के 6.
No person. Backward.
16
16.
by lordships.
Come to the last bottom. Medical cases only. I certified that the life insured has signed and put his signature in my presence after admitting all the answers, questions from numbers 10 onwards in this form has been correctly recorded. So this is by the empaneled doctor. Now you come to page 14. D.
Are you suffering or you have suffer from liver, stomach, heart, lungs, kidney, brain or nervous system? No.
So this is your declaration.
My declaration. My declaration, not per se, it goes unchecked, unverified. Clinically examined by doctors to have found to be correctly recorded.
Okay, fine, got it. Now read.
Not correctly stated, may not correctly recorded. I'm on that. My lordships.
Hmm.
May I go to the award?
Hmm.
My page 25. How they counter it. No, I will continue with that, my lord. Page 24. Last line.
He objected.
He objected to the admission of Exhibit H and I register and its entries in evidence on the ground that those registers do not bear the signature of its proprietor nor the seal of the nursing home, and further when Dr. P.C. Sharma, although available, was not examined. According to him, the Exhibit H and Exhibit I are manufactured registers and entries in the name of deceased and are false and cannot be relied to repudiate the claim of the petitioners. Countering the submissions, Sri A.K. Das, learned advocate of the opposite parties, has justified the repudiation by contending that the Exhibit H and I records of the nursing home cannot be brushed aside and non-examinations of Dr. P.C. Sharma is of no consequence. According to him, Exhibit H3 and I2 are entries in the name and address of the deceased and signature of his son Abdul Mumin merely for the Abdul Momin, petition number 2 in this case also appears in Exhibit H3, and therefore merely for the fact that the medical officers of LIC had certified the health condition of the deceased is good is not of much consequence. According to him, when an information on a specific aspect is asked from in Exhibit A, Exhibit B proposal forms, the assured was under a solemn obligation to make true and full disclosure of the information leading to his health, which was within his knowledge, and non-disclosure of the misstatement has vitiated the contract of insurance. His relied on the decision of the appeal so-and-so, the Honorable MP so-and-so, and also Kerala High Court so-and-so. We have considered the rival submissions advanced on behalf of both the parties and scrutinized the evidence on record, and also we have gone through the for said decisions. We are aware that the strict principles of Evidence Act are not applicable, and we are guided by the principles of natural justice, objectivity, fair play in deciding the disputes before us. From the totality of the facts and circumstances brought on record, prima facie, it would appear that the deceased had not furnished correct statements as regards his health condition. It would appear that the forms were filled up by the agent. It would also appear that the forms were filled up by the agent. We find that the death of the policyholder in the year 2005, the petitioners have been pursuing the benefit under the policy and in the alternative for refund of the premium 42616. Situated thus, we have the considered view that it would be just and fair to allow the petitioners to receive back the paid premiums. We therefore direct so-and-so to pay so-and-so, my lordships. I would not
The
mind the
short
judge.
long and short of this is that the non-disclosure was held against you.
I'm not on that. As an officer of the court, at this age, after so many years, it doesn't matter which way the judgment would go. But on a point of law, I'm just thinking aloud that what if we take it to the extreme? There was a non-disclosure. Just testing it, my lord. There was a non-disclosure or a wrong disclosure, which would not be proved by evidence, which crossed the period of limitation, hit by 45, and the ingredients of 45 which gave them the benefit were not established, and they learned low-card alert, my lord, permanent low-card alert, merely concluded on prima facie views on speculations and not guided by the materials on record. Those considerations, my lord, were perhaps not adequate to conclude against me or in their favor. Had the evidence been discussed in detail to show that no, although strict rules would not play, but these things are there which would outweigh your claim or outweigh your negation. That's all, my lord. I cannot go into like civil suit, I cannot go dive deep.
Support, verify your submissions by some judge,
My lordships,
some judgments of the Supreme Court or of this. court.
that I would have to go through.
That's what.
That is what, my lord.
That
I'm
is
not,
prima facie you got to do. Just merely saying will not do.
what I'm
You
on
will
is
have to
that,
establish it.
my lordships, what
45 has two parts.
yes, two parts.
I am on the
Second
second part.
I am also on the second part. How they
Second,
raised
How do they raise? They
and
have,
discharge that burden.
they have raised a situation wherein it is brought on record
Correct.
that you were suffering from a heart disease. Forget the pacemaker.
It's okay. It's okay.
You were suffering from a heart disease for which you had undergone treatment.
Right.
Now, if that is the position, why was it not disclosed?
Disclosed. This is number one.
Solved.
That's all. This is number one.
It's a contract of faith.
This Oberama Fidesz, my lord. Number one. And if I balance it with the second part, the legal justification requirement of a medical officer to assess my statement, even if I go for insurance today, my lord, term insurance or life insurance or health insurance, I would have everything tested. They even go to the extent of the ELISA test, my lord. So now when they tested me, my lord,
Mr. Banik,
they say the doctors were wrong.
that is the tragedy we have. Practically, you also know.
I know.
I also know. We can't bring it on record. How the medical examiner.
But they tested. I can show that because my insurance money in person, my lord, they had all the tests done.
Online, I would have otherwise disclosed many things.
Blood, nicotine, etc. Everything is tested. What you would have, what you consume, what you drink, whether on this heart, lungs, liver, everything. We have to give a disclosure, which is subsequently checked by them. Otherwise, the necessity of a medical examiner to examine, and how can they brush away? I put a question, my lord, that my doctors were wrong. Then face the consequences. That is an admission. They say the doctors will get a judgment on that, my lord. I understand. A very narrow campus.
Yes, Mr.
First of all, their complaint. Look at that. PVC. What was their complaint?
Hmm.
My lord takes what comes to the prayer portion.
Hmm.
The petitioner may the petitioner prays for award declaring to the officer bound by law, pity, pay sum of rupees so and so. With interest, arrears, nomination that the alternatively lost. That is a prayer. Alternatively, petitioner prays for declaration. Petitioners are entitled to get back all deposited money in the mode of premium paid by the policyholder to the last payment along with interest. So that is the finding of the learned. If my lord goes to the judgment of the permanent look in the very opening page. Page 23, Lordship, for a moment.
Hmm.
Page 23.
Hmm.
Hence, I am just reading the relevant portion. Hence, the petitioners have filed this case seeking death benefit under the policy and in alternative refund the premiums.
Which you have given there, but permanent has given and they have also.
Yeah. And that is their prayer in the nation.
Okay.
So this is first part of the matter that their petition stood allowed, and this it is their prayer in the application to refund back. The learned Lok Adalat has given them what remains.
That's fine, but when there is a mean prayer and he is pursuing this
No,
without
that is
prejudice to the. Now,
Exactly.
Mr. Nandi,
Yes.
what is the cause of the death of the insured?
heart stroke.
Where do I get that?
That is their say, Lordship.
Any medical document to that effect?
LC, Lordship. That's it.
That certificate will not have that.
Maybe in the evidence.
Just find that.
In paragraph 5,
Hmm.
medical officer of medical certificate cause of death.
What is that?
is LCM.
Medical attendance certificate exhibit 4, page 36. May I also join with him, my lord, in the LCR?
Mr. Bonik seems to have softened down a lot. Or is it the case? Mr. Bonik? Mr. Bonik seemed to have softened down a lot from what I knew. Is it the effect of the case or something else?
My lord. Page 36, stroke.
Hypertensive stroke.
Hypertensive
I
stroke.
found it yesterday. I missed it out very.
We have the exhibit details, page numbers and all, only because of that. The reason. This is by Dr. Khandekar Gulab Hussain. Medical officer, exhibit 4, page 36.
That is the part of the petition.
And this is an exhibit. I exhibited this document, my lord, as exhibit 4. My lordships, without going into the nitty-gritties of the evidence, my lord, it would be a dangerous thing if the doctors of the LIC are permitted to say anything, and then the LIC can say, no, no, my doctors were wrong, we'll repudiate. It will have a cascadian impact on the society. I am not on the merits of this case at all. Lordship will lay down the law.
Exactly, that is what is happening.
That this is dangerous to say. I'm on the larger issue, my lord. I may lose this case, nothing will happen. But larger issue, if the doctors are allowed to say something and the LIC would say quite another, and say nothing.
That you have been granted your alternative prayer. Can you pursue your mission?
This is one view, my lord. Lordship may take that view and end this matter. But I am before a court of law on a substantial points of
I'm
law.
neither going into your that preliminary objection about maintainability of the writ petition, nor
I understand. If the
nor into
alternative,
the plea taken that you have already
Correct.
withdrawn them. I'm not going into either. I'm on merits.
Lordship, I'm only on a very small point which will affect the society in rem, my lord. Would it be, I put the question to myself, my lord, would it be permissible to the doctors of any insurance company in rem to record anything what they want, pass it off as correct, and when the claim is raised, they take the insurance premiums and all. The moment the claim is raised, then the insurance authority would take a view. No, no, doctors were wrong. Everyone suffers from ailment, right or wrong. It has to be there in the agreement, in the contract. Once you verify my statements and then record it by have a doctor, is a qualified doctor. It's not their clerk. Or this judgment would go against the society, my lord, forever. This stand of which is what is troubling me, not the merits of the matter.
Yes, Mr. Nandi.
Lordship, for the policy of insurance was folded within years of the policy. So it's fine. Okay, then.
Oh, no, no.
Section 45 first part will not be attracted.
It will be attracted.
No, it will be attracted in
I
its
will address that, my lord. I will address that.
second part.
Yes.
So, Nandi, the plea taken by you is not heart ailment. Also, it will be covered by heart ailment. The presence of the pacemaker. That was not disclosed. But why did your doctor not detect it? Pacemaker can be detected by any trained medical. You and I can.
Yes.
It was not, he was not examination.
Then-
That my learned, what
Where do I get that he was not subjected to a clinical examination, although he was 59?
not required.
Why? Your policy requires that a senior citizen or a near about senior citizen would be subject to, there has to be a medical certificate from your doctor accompanying. If that be so, and the doctor says everything is perfect, then how can you again fall back on that to
Lordship.
repudiate the claim?
May I submit? The policy holder needs the time of break. And that we have put in evidence.
That is subsequent. That is subsequent. How did you draw or derive satisfaction that you are going to undertake this policy, underwrite this policy, when the proposal form came before you?
We take the policy of insurance lordship is a contract.
Oh.
It's a contract based on your facts. As laid down by the Honorable Apex Court
See,
on Knight's case.
the disclosure is only not at the end of the insured. It's also at the end of the insurer.
Accepted based accepting this as formal truth.
But there was a medical examination made by you.
There was a medical action.
And this is something which could have been detected.
No, was not detected.
Why?
Because
That means your panel doctors did not do the job properly.
I am relying on this judgment of the basic judgment of court.
Which case?
First case is on Knight's case.
Then there is Chaco.
No,
PC
before
Chaco.
that, the
Before
base
that, Chaco is before that. Before this.
Chaco is after that.
After this.
Yes, the base judgment is Mithulal Nayak's, 1962. There is, thereafter is Lordship is Chaco. My lord,
Yes.
I'm reading paragraph 8. May I take your lordships? The conditions applicable for second part of section 45. My lordship, this statement must be material or must suppress, which is material to disclose. The first thing, which suppression must be fraudulently made, the policy holder, and number 3, that is important, lordship. The policyholder must have known at the time of making the statement.
These are the ingredients of the second part of 45.
Yes. That it was false or that it was suppressed, which was material to disclose. Now, your lordship, policyholder knew at the time of making the policy that it was material to disclose that he was get under on implementation of pacemaker. And the cause of his death is also relating to this. And the cause of his death is separate, lordship, diabetes.
He died in a road accident or something. It would have been.
Separate. But the cause of death and the implementation of pacemaker are related to each other. And that is why I'm hampering before your lordship. And the cause of death being otherwise would have not no case. Now, lordship, the Honorable Apex Court, may I take your lordship to paragraph 9. We may, I'm reading, lordship. We may here dispose of the third question. The learned counsel for the appellant has argued that Mahajan Jewelers was examined under the direction of the respondent company by as many as 4 doctors. Here also, my lord, is same thing. Namely, Dr. So-and-so, Dr. So-and-so, Dr. So-and-so. It is further pointed out that Mahajan Jewelers had correctly disclosed that he was suffered previously from so-and-so, so-and-so, so-and-so. Kapadia in his pointed out, specifically asked to examine Mahajan in view of conflicting reports Dr. Desai has submitted. These facts, the argument has been has been that the respondent company had full knowledge, all facts, the state of health of Majanlal Deola have been knowledge of full facts. It was not open to the respondent company to call the policy in question on the basis of the answers given by Majanlal Deola in the proposal of his personal statement, even though those answers were inaccurate. Learned counsel for the appellant has referred to us the explanation 19 of the Indian Contract Act in support of Majanlal Deola was examined by 4 doctors. It is also true the respondent company had put it conflicting reports of Dr. Desai and specifically asked Dr. Kapadia to examine Majanlal Deo in view of the reports submitted by Mr. Desai. Yet it must be pointed out that the respondent company had no means knowing that Majanlal had been treated for serious ailments of secondary anemia following dilation of heart in September 1943 by Dr. Lakshmanan. Nor it can be said the respondent company had the knowledge of those facts. They would have made any difference. The principle underlying Section 9, definition to Section 19 of the Contract Act is false representation. Whether fraudulent or innocent is irrelevant if it is not induced by the party to whom it is made act on by entering into a contract. We do not think principle applies in the present case. The terms of the policy make it clear that the amendments made in this page as to the state of health they issued in the proposal form and the personal statements were on the basis of contract within the parties, circumstances that Majanlal Deola had taken the pains to falsify or conceal that he had been treated for serious ailment only a few months before this policy has taken shows that the falsification or concealment had an important bearing in obtaining the third party's contract. A man who has so acted cannot afterwards turn around and say, it would have been no difference that made it true. Next, Lordship, Asha Goel's judgment, my Lord is well aware.
I'm aware of nothing.
Here it will paragraph 12 and paragraph 14. And in paragraph 13, it is relied on the decision of Mitholal Naik. Goel's case, paragraph 13, judgment of Mitholal Naik has been relied upon. And in paragraph 12, stated that the contract of insurance included a contract of life insurance or contracts Uberima facts, and every material fact must be disclosed. Otherwise, there is good ground of rescission of contract. The duty to disclose material facts continues right up to the conclusion of contract. Also implies any material alteration in the character of the risk which may place between the proposal and its acceptance. If there is any misstatements or suppression of facts, material fact, the policy can be called into questions for determination of the question whether there has been suppression of any material facts. It may be necessary to examine whether suppression relates to facts which are exclusive knowledge of the person intending to take policy, and it could be ascertained by a reasonable query and by prudent person. Your decision, Lordships.
Yes. Next.
Decision of this honorable division bench of the honorable court.
Life insurance case.
Yes, Lordship. Is fraudulent separation of material facts. Lastly, but not the least, Lordship,
Cook case has been distinguished subsequently, no? Has been distinguished. When?
Tepco versus life insurance.
Hmm.
Company. Please stand away. Those are my decisions.
Give me a copy of that also. I'll incorporate that.
Go ahead. Okay.
See, this is a learning experience for this court.
I'll provide the development of the law on this point on the, I'll just give it, I'll not argue on that, Miller. But these were followed and eventually in a different forum though.
Base decision is Mithulal Naik's.
Hmm.
Prior to that, there was no,
No, that I was not aware. Now I've got it.
that is the base decision.
Mithulal Naik has been followed here.
Mithulal Naik has been followed in subsequent judgment also. Many judgments later on, this judgment has been already
Heard
followed.
Mr. SP, Mr. S. Bonik, learned counsel for the petitioner. Also heard Mr. K. K. Nandi, learned standing counsel, FCI, standing counsel, LICI.
So I'm panel advocate. Lord.
Counsel appearing for the LICI respondents. Also, the Mr. Bonik submits that he would in rejoinder make further submissions and accordingly praise that the matter be taken up on Thursday to facilitate him to make his submissions in the matter on Friday.
I vividly remember reading somewhere, I'm not equipped with that, that when the insurance company exploits on negative answers, the burden is them to show that they had acted so in discharge of their duties with due diligence. If the doctor's examination is not in due diligence, they cannot shy away from the consequences of it. I vividly recall there's a judgment on that method. It followed Chakwa in all series.
Rejoinder. So accordingly, registry to list this matter again on Friday for further hearing.
Part
Give me the judgments by Thursday.
Yes, yes,
Give it to her.
13 part.
For further hearing.
Further hearing. 13 part.
Further hearing
Further
on
hearing.
Friday.
Lordship, it's grateful me.
I'm open to that point, but you may have a
Yes, yes.
Everest to complain. Thursday, Friday. Record to.
Obliged, Lordship.
Obliged.
I remember for the timing that
Okay. Who is working now?
Now, Lordship, the private respondent are working.
Who is appearing for the private respondent? You are appearing.
Mr. Soike was there.
Who were basically, your services were terminated. The ground that the advertisement specified that you should be within the Anganwadi area.
Yeah, yes.
But during, just after the issuance of the advertisement, the notification
Yes.
came that now it will be the village.
In the village.
So they considered that aspect of the matter and you having scored the highest.
Yes.
There is no dispute that you
Yes,
scored the
yes.
highest marks. So you were brought, you were appointed.
Appointed.
Then there was a case before this court.
Yes.
Therein, because they did not bring on record anything that was Your appointments when the court was under the impression that no appointments were made.
Yes, that is the factual, factual.
And proceeded to direct for issuance of orders in your favor.
Yes,
So thereafter, you come up
lodge,
and this court, noticing the earlier judgment,
yes,
says that that cannot be done,
lodge,
restored.
lodge,
Then they file a review.
lodge.
And in that review, this court has now been saddled with now the matter has come back for
Lodge.
fresh.
Sorry,
hearing.
yes.
Yes, what do you have to, oh, Mr. Dartwill? Yes, madam, what is your stand? Who is your senior? He is here.
He'll come, Lodge, we are informed. Lodge. After some time, Lodge. Obliged, Lodge.
Yes, sir.
Pass over for time being.
Time नहीं, Lodge.
You call him.
He's a return.
He'll come, Lodge, he has informed me. Lodge.
He'll come. So now you are there.
Yes, yes,
Item number 6.
yes, yes.
Yes,
I
what
will
is
do.
your case?
I'll do, my lord, probably Mr.
We have already adjourned Mr. Saik Medhi for many times. We will hear Mr. Nath now.
My lord, lordship on earlier date made a query that what was the fate of the criminal case.
Hmm.
I have with the judgment. He has been acquitted,
Okay, fine. That will have no bearing here.
and that is your lordship as a query. So
That is for my consumption.
my
But I can't bring it through my hands to the order because
Right.
that is a separate thing altogether.
yes, yes.
Now, what is the error here in the?
Error, my lord, the allegations made by the lady has been taken in toto in face value. And she is the complainant as if her version is truth, my version has not been considered.
That is, Mr. Nath, this is preponderance of probabilities.
It is there. I will come to this, but document is to be
No,
proved.
anything on law,
Yes, I will rely on.
procedure or on something.
I will do. But except the procedure, my lord, in Nagi's case, Rup Singh Negi, lordship relied on argument on Narendra Modi Arja. Rup Singh case, Supreme Court is a content required to be proved. Here is what is my charge, that I made a that I am reading the charge, then I am coming.
Any plea on the procedural part?
So I have, no, my lord, procedural, they have taken this. Naturally, I am the complainant. What I even saying, they have
That is
taken.
on merits.
That is not.
That is on
Procedure,
merits.
if that is on Supreme Court, has,
I find the paragraph 12.
Well.
You have said that this penalty cannot be imposed under section 11.
that is.
What do you have to say on that?
No, my lord, I have come to the judgment. I have, because Ghulam
That is
Rasul,
gone.
Ghulam Rasul case, if it is read to 27,
It
penalty is
is
read
not
to
read with
27, then
27 because this court has also passed.
yes, yes, Ghulam Rasul
That,
judgment.
Ghulam Rasul, and thereafter there are two,
Yes,
three
yes.
judgments, recent also Supreme Court.
Yes,
Says that 11 is an exception. It's not like we understand what dismissal, removal or compulsory retirement in the normal civil service.
yes.
This is a minor penalty because of 9 and 10. Section 9 and 10 of the
CRPF. Act.
CRPF Act, it says in lieu of or in so and so, along with dismissal from service, this can be in lieu of what? In lieu of imprisonment.
In prison,
So that goes.
that goes.
You're not pressing.
Not. Because the Ghulam Rasul judgment, I have, because the penalty is read with section
Section 27, rule now.
Sec-
Section 11 read with rule 27.
Rule 27. So rule 27, the power has to the. Now I am coming to the lordship with the charge sheet. What is the charge? And how it has come to the conclusion findings. Article 1, page 29. Page 29.
20?
9. Charge. That was in Hindi. I did a translation. That force number so and so, while in service, CRPS has made a fake service identity card. First of all, of his own and inserted there is a color photo. It should be proved. In the inquiry, the complainant lady has stated that you give me a photocopy. Her complaint,
Along with the photograph.
along with the photo, that's it. And colored, their allegation is that I colored photo. That is, there is no such evidence that I inserted a colored photo because I am interested. I am
Where
interested.
is Mr. Mehdi?
Because I am a, the lady is she is not, could not get
You
the
take down notes.
marriage could not be materialized. So the lady was a frustration because the marriage was, they along with the petitioner, her marriage was not
You are
materialized.
the reason for that frustration.
A lot.
You are the reason for that frustration.
That is what. So her,
You wanted to marry her, but
so she
you
is,
wanted, your parents did not allow, so you did not marry.
yes,
And you went
that-
and married
yes,
somebody.
lordship has gone through,
Oh.
lordship obliged. That is the, what is happening?
Okay, what is the charge? Hmm.
Charge is that in service CRP has made a fake service identity card of his own and inserted then his color photo. Where is that proof? I inserted.
Oh, fine, read.
Then in identity card, his name has been changed as Devashish Singh, charged under the description of identity card. The employee in the fake identity card has changed his name as GT Krishnan, and one photocopy of the fake identity card has been given to the guard, daughter of the that one introducing himself. That is it. First of all, there should be some findings, there must be evidence that I made this photo card and I give that. She has what?
That is not the end of the allegation. You read
Allegation.
further.
Then my lord is come. Daughter of the village in Kachar. Introducing him, Devashish Singh, he engaged in love affairs with him, L. Nandita Singh, daughter of Fulbanu Singh, since November 2010. As on, he married her at Silchar Court and Serpe Chart has tampered government document. Tampered government document. As such, being member of the force, I have produced my original identity card in the inquiry. Where is the tampering, scope of tampering?
Oh, that is not the one. That is not the case. Here, because this card was required to register your marriage.
Yes,
That agreement,
yes,
right?
yes,
So you gave that girl a identity card
yes,
with a photograph.
yes.
So that was used for your identity.
She has stated the photograph given in inquiry.
We will come to that.
Yes.
Photograph along with the identity card.
Yes.
Photograph is set separately.
Separately.
Be that as it may.
Yeah.
That was used for the purpose of
Marriage
execution of the agreement,
Marriage certificate.
marriage certificate.
And there
So
is no
that
marriage
you
certificate.
have not denied.
There is no marriage certificate.
No marriage certificate, agreement.
No, agreement is she said that.
That is different aspect, Mr. Nutt. That agreement is not a valid one.
Yes,
But the allegation herein is you with that girl,
that,
you enticed her to execute that agreement with you.
yes, that is her allegation.
Be that as it may.
It is.
What is your, okay, next one.
Next one. In the Ijal Singh, he is serving in CRPF, has introduced himself as Devashish Singh to MLN, the daughter of the, and made love affair with her since November 2010. And on 15/7/2013, he has married L. Nandita Singh at Silchar Court. The employee without divorce to his first wife, L. Nandita Singh, has married Srimati Premavati Singh, a daughter of so-and-so, and as per Rule 15 of the CRPF Rules 1955, no member of the force whose wife is alive shall marry for second time without permission. Government also shall not marry for second time, which is not permissible under the law. But the employee has married at the second time without divorce, first wife, and marriage was not proved in the inquiry. So this charge, my humble submission is this charge is not proved. Then, my lord, Article 3, that the CRPF has introduced himself, the Devashish Singh so-and-so, L. Nandita Singh, daughter, Fulbabu Singh, and made love affair with the since so-and-so, is married L. Nandita Singh, Silchar Court. He has cheated M. Nandita Singh, daughter of the Fulbanu Singh, and Srimati L. Nandita Singh has lost case on under section so-and-so. The employee has not informed about the case in the department. So my humble submission, an FIR, information of FIR cannot be the basis of a dismissal from service.
No, it's not the basis of that. It's a cumulative reading of the whole thing.
Yes,
First two charges is connected to the third charge in the form that that girl had lodged an FIR. You are a member of the force. You should have brought it to our notice that there is a criminal case pending in it. It may not affect your service matter, because it was only an FIR. But that information was not given.
yes, that is charge.
And that information not given because the presumption is that it will lead to disclosure of the first two charges.
Yes, Lordship may interpret like this, but
I'm not interpreting, it's the
That is-
interpretation of
they
the
are-
respondents.
they are at present. So my,
Then, what is the,
I am coming to the, my lord, these are the charges. Now he denied page 33, annexure 5 in his third set denied. He has given details, he denied that most humbly I beg to page 33, most humbly I beg to state that the allegations leveled against me so and so are baseless and false. I have not made any fake service identity card by inserting there a colored photocopy and changing name from the mine, nor did I give fake identity card to anyone. I have the identity card of my name, city so and so, with me, whereas as per allegation, my identity card has number 101664, with charge change name of city GD Devashish Singh. I have not given identity card to L. Nandita Singh as proof, nor I have married with L. Nandita Singh, since the official did not give any identity card to L. Nandita Singh, nor he married to L. Nandita Singh, the allegation.
where is that agreement for marriage?
That is it at page. Page, my lord, 26. This is an affidavit.
Have you denied your signature here in the inquiry?
That was not put. That was not asked question, was not.
Be done as it may.
Not, it was not proved.
This was
This-
the document which was produced.
This was not proved in the inquiry.
Why? She produced this.
The produced not proved. Inquiry required to be proved.
How?
I am to ask.
PW1, you did not cross her on
I
this.
am to ask. I have crossed. I have
We
given.
got this agreement.
I have given this.
Okay,
Because I
where is
have
that
an
agreement.
type
So,
copy. I have shown Lordship.
Where?
I am coming to the inquiry proceeding.
Where have you disputed
Page
this?
36. Because record was also, probably record is also there.
Hmm.
It was called for. Page 35. Etc. My lord, the question cross I am coming, page 36. Bottom. The question and answer to this L. Nandita Singh, Sensor, inquiry officer.
By inquiry officer.
Inquiry officer. Presenting an inquiry officer is presence of the petitioner. Since you know when it is, since 2009, sir. When I got married with this, I got married on 14/7/2000 at the Hanuman Mandir at Tulapati Silchar. Did you got marriage registered? No, sir. But one affidavit has been made and signed in the Silchar court. Then I am coming. Can you say that the city Judicial Singh was with you and when affidavit was made? Yes, sir. At the time of making the affidavit, Ujjwal Singh was with me. Yes, saying whether these are her deposition, not cross. Whether the marriage was done on the consent of the both of you? Yes, sir. Both of the consent understanding marriage was held. Can you tell the photo of the signature of the affidavit of the alias Devashish Singh? Yes, sir. He came to the married second case. I came noted by 22nd from my friends. How you ascertain Devashish Singh is not the same Ujjwal Singh I knew from Ujjwal Singh parents when I went to same residence on 1/1/14. Whether Devashish Singh alias Ujjwal Singh identity card? Yes, sir. Photocopy of the identity card Devashish Singh issued by the CRPO was given to me. That was photocopy given to me. Did you make any FIR against? Yes, mate. Can you tell you the FIR against forces? Ujjwal Singh he cheated me and spoiled my life. FIR police station. Do you want to tell something more except this? Except this, in support of my statement, I want to give some evidence. Question and answer location asked by sources. Presence in inquiry officer, presenting officer. Since when and by which you know Ujjwal Singh, I knew him Devashish Singh from 2009. Since when you know Ujjwal Singh, I know he was Ujjwal Singh 2019, but no, on receipt of the I-card in the name of the Devashish, I am confused, and on the photocopy I-card in the signature was also of Devashish. Hence, I believe that Devashish is genuine, but I went to his residence and consulted Ujjwal Singh. According to the statement, in his temple, he got married, and on that occasion, who were present. I got married in Hanuman Mandir, Tulapati, none of other, both of us were present. According to your statement, where did you reside after marriage? I reside in the quarter on such and so. What is your religion? My religion is same. When you went to the home after marriage, I went to home on 1/1/14 after marriage. When you informed your parent about it was reason, it is informing the marriage. Our marriage was held and mutual understanding, both of us. Elder sister of Ujjwal was unmarried. Ujjwal told me, wait till the marriage of the sister. whether your parents required it, when and where the I card of Debashish is given to you by Ujjwal Singh. Said card was given me after my marriage on October 2013. At the time of signing this affidavit, at the present, yes, both of us, the
Then-
advocate was present.
So this will lead to that affidavit being sworn by you.
That is, I am coming, that is her version. From the,
No, this is a cross.
no,
You have not elicited anything.
no.
This is the examination by the by force number so and so in presence of inquiry officer and presenting officer.
Asked, yes, cross. That is her, that is her version. That is her version. Can you
Not
tell?
the person, this is a version in cross.
No, cross. She is telling
Mm.
that I am disputing. Whether you asked SIM to create a BSNL, from where you got the photo of the Ujjwal Singh ficking I card. When Ujjwal Singh gave me the CRPF I card, then he gave me one photocopy also.
Photocopy.
One copy of photo also. So the question of the Ujjwal Singh in the presence of the inquiry officer and a presenting officer, the so and so. So my submission is that, my lord, on the basis. Charge is that I inserted a colored photo, make a
Okay,
photo.
that is what you have established by yourself
And
in the
second,
inquiry.
and second thing is that for the purpose of marriage established. Whether a marriage
We are not on that. We are
that
only on the
charge
count
to.
that we are on the count that you have projected yourself as Debashish Sinha, induced that girl to execute an agreement with you. She was under the belief that you are his wife. And see, as per the Hindu law, you have got married in a temple.
No. My lord, this is my
The-
extract.
the-
This is
the-
extract
the-
of version. What I am saying, I denied everything. It is her version.
This is
I
the
denied
version
everything.
in cross. You have not been able
No,
to dislodge.
She is a question answer. There is question answer. She has
So in a department
another-
proceeding, is it this? I
an-
say yes, you say no.
another. My submission is that, my lord,
Mm.
whether the Hindu marriage law, the marriage is like can be held without Saptapadi, without the following the ceremony. This is an
Where have you asked all this?
yes. I have before the appellate authority I have stated.
No, forget the appellate. Where have you stated that the girl, that how do you think we have married? We have not married. We cannot be held to be married.
Yes,
Where are
yes.
these
He has
questions?
stated. He is not married because it is a just
Where is the question?
entire document, my lord.
Oh,
It is-
what the
I have-
evidence is here.
I have some extract I have given. This is not the
So
entire.
this extract is the extract wherein you wanted.
That is
Now, if I go there, it will be against you. Some maybe more material against you.
No. But Lordship may go through the record also. Because I have categorically stated, I have not married you.
Where have you asked her that question? That how did you come to the impression that we are husband and wife? What happened to your marriage with the other girl? Still subsisting?
Yes. This is not marriage, my lord.
No,
How
no,
that can
that
be?
is still subsisting.
Here
What
that
are you
is
doing?
subsisting. This marriage is she is
What
claiming.
are you doing?
What I have produced this. Whether law says that marriage is like this marriage.
Show me something.
Yes. I have stated everything. No, that is question answer. Whether it is concluded that it is a marriage.
What is that question answer requirement? Is it of no value?
She has replied what I answered question.
That is it. That is cross, mister.
Yes, cross. On interpretation, the cross.
We
Whether
cannot
that,
go and interpret something which is not
my
there.
lord, my submission is that on interpretation on answering, whether that can be concluded it's a valid marriage or marriage.
The conclusion here is of not a valid marriage. Conclusion here in whether
Then, my lord,
You
charge of bigamy for the purpose of dismissal, there should be a marriage first. Marriage to be proved. I am judgment, my lord. I have learned.
okay, show me.
Marriage must be proved. I have the judgment of the Honorable Supreme Court. Marriage must be proved. And our High Court judgment also.
That is show me.
2005 4 GLT. For bigamy ingredients, spectrum of the second marriage must be proved.
2005.
2005 4 GLT 77. Relied on the, my lord, Supreme Court judgment I am relying. 5 GLT, page 77.
2005, 4
4
GLT,
GLT, page 77.
Yes.
Gopal Likharu versus State of Assam Maintenance. Another judgment when 1965 to AIR 1965 Supreme Court 1564. Section 494 IPC must be satisfied. Then, my lord, there can be concluded that yes, there is marriage.
Then any more further?
And then, my lord, on proceedings, my lord, lordship, I am relying on judgment. I am coming to the inquiry report in conclusion of
Where
the
is your
inquiry.
judgment, Supreme Court?
So that Supreme Court judgment, yes, I am there. Na kudi. What is the charge before here? It is the exactly in FIR. And the criminal case I have been acquitted.
Criminal case acquittal in what form?
My lord, acquitted technical form because, but after all,
Benefit of doubt.
no. Acquittal because procedure has an inquiry. And I am relying, my lord, Rup Singh Negi's case, criminal case also referred here.
Where is that criminal judgment? Of
I am giving lordship. Okay, court. It will love it. No, repetition. It will love it. That is the order of the additional session judge FTC at Silchar. Date of hearing on 25/5/15 and date of judgment 30/5/15. He has been discharged from the section 468, 471, 417 of the IPC.
That is because it was a cognizable case without a permission from the
Yes,
CJM, they proceeded to
Yes,
argue.
No.
That is neither here nor there.
that is. But because fate of the criminal case I shall lordship. That is.
That will not support you.
That is it. Now I am coming, that is because the criminally also not proved.
criminally not proved because of
Technical
some
ground.
technical.
Yes, yes. But
So you cannot
some,
say-
somewhere it is to be proved.
Why? The departmental proceeding is enough.
No, no, my lord, merits to be proved.
That we don't know. You
Then
had
how
opportunity here.
bigamy should be charged and the second marriage? If it is not proved, then how the charge? That is what I am
Here
saying.
it is not the case of a second marriage. It is the case of you projecting as the husband, as Debashish Sinha before that girl, inducing her to execute an agreement. You have not denied that agreement. Now, as far as that fraud you have committed, we will not permit you to take a plea that there was no valid marriage.
This is not charged in the disciplinary proceeding.
That is an interpretation.
No, my lord, my humble submission, this is not the charge. Then I am coming,
Okay,
my lord,
next.
I am showing you the law of the 2009 in the case of
Rup Singh Negi.
Rup Singh. 570, 2009 2 SCC 570. I am relying on this, my lord, I am giving a law. And Life Insurance Corporation of India versus Rampal Singh Basin, 2009 Rup Singh Negi.
Hmm.
Page 14, sorry, para 14, page
What?
5, page Rup Singh Negi, page 577, para 14. Indisputably, a departmental proceeding is a quasi-judicial proceedings. The inquiry officer performs as a quasi-judicial function. The charge level against the delinquent officer must be found to have been proved. The inquiry officer has a duty to arrive at a finding upon taking into consideration the materials brought on record by the parties. The
Okay,
purport,
got it.
my lord,
Got it.
my lord. Then, my lord,
Yes.
when para 19, I am also relying Rup Singh Negi.
Okay.
The judgment in the case of decree passed in the presence of Narendra Modi IDO has attained finality. In the said suit, the inquiry report in the disciplinary proceeding was considered. Same was held to have been based on no evidence. The appellant, there is a aforementioned situation, filed a writ petition questioning the validity of the disciplinary proceeding. The same was dismissed. This court held that when a crucial findings like forgery, here is the charge is forgery. Forgery was arrived at on an evidence which are honest in the eye of law. The civil court would have jurisdiction to interfere into the matter. This court emphasized that a finding can be arrived with a binding fact if there is some evidence on record. It has further found that order of the appellate authority suffered of non-application of mind. Then, my lord, in LIC versus Rampal Singh Basin, 2010 4 SCC 491.
Okay, got it. Now, what is the finding of the inquiry officer?
Inquiry officer's finding, I am correct. Page 40, inquiry report start. 24, page 40. Forwarding of the inquiry report, statement, everything. Page 47, statement of the defense side. Statement of the force defense side, page 47. Statement of the force it is recorded in presence of the underside presenting officer as per the statement judging the allegation leveled against me by demolition numbers is not true and false. Alice Demoti have not been make a fake service identity card by inserting here in a colored photocopy and changing name of the mine, nor I have gave a fake identity card to anyone. I have identity card of my own that is judging with me, whereas as per the allegation, the identity card has been so charged with depositing. I have not given identity card to El Nandar Singh as proof, nor I have married with El Nandar Singh since the official did not give any identity card else in the thing nor ki married else ke. As such allegation embodied is false and baseless. This is my submission and the charge inquiry officer also taken into consideration. But my submission, there is no conclusion and nothing analysis on from record. So because once I have denied allegation that I have not made, it was the duty by an independent agency or independent entity that I have made it. And the charge is that you have inserted colored photograph. L. Nandit Singh, NGO office in Silchar is in my village. As such, he has got my. Then, my lord, conclusion of the coming to the conclusive part, that is charge number, allegation charge number, page 49. On the basis of the statement of witness and document produced, the allegation that force number while in service has made a fake service identity card of his own inserted therein. As if the IO seen that I inserted therein. Who seen? Who has seen? Where is that colored photograph? A photo with the iCard. Photocopy anybody can make and can produce. And the IO treated is a gospel truth. Once I have denied it, required to be proved. On one inserted there in colored photocopy. But my submission that I did not make has been ignored. In identity card, his name has been changed as Devashish Singh and changed other description in the identity card.
Okay. Anything more?
My page 51, on the basis of the evidence produced and statement witness, allegation MOD Ujjwal Singh, the CRP has introduced himself as Devashish Singh, so and so forth. He has merited. My last submission message is dismissal from service. Worship may be pleased to consider it is a dismissal from service. And he is out of service last 11 years. Whether these charges, and no one sees that I inserted colored photograph, and it said, whether dismissal is. Page 52, my lord, is a penalty order. Penalty order, every repetition is the same. And page 54 is a conclusion. Hence, the undersigned, after careful study of the inquiry report, related document statement has come to the conclusion force number 7, exercising the power conferred under Rule 11(1) and read with 27 AS CRPF Rules 1950.
Okay.
I pass.
Yes, Mr. Mehdi.
Yes. That the pot is he's white man. Or his legal white man. I'm reading 43 man. How it is made. Of the Premabuti Singh, daughter of Swans. December 2011, the first time I received one missed call from my mobile. Thereafter, when I called back and asked, who are you? Continue to talk over phone. After I lost my phone as a I got a call from or started. A month of February 2013. On come in my if we can so we made on 5th 2013 at Sigmund.
What is there? What do you want to prove?
See in this also second one Shiv temple. And this there is on
He's a Shiv Bhakt. How can you hold it against him? How have you proved the second marriage? That the bigamous marriage, how have you proved it?
One affidavit filed.
Whether an affidavit, by way of an affidavit, a marriage is held to be solemnized.
My lord, both are the same, my lord. So we
No, second marriage, there is a certificate. But the first marriage, where is the certificate?
Affidavit, first affidavit, my lord. Affidavit, next certificate.
With regard to the marriage, first marriage, what is the evidence? Only that affidavit. Whether an affidavit is enough.
This the affidavit.
That is fraud. That is misrepresentation. Second charge, how have you proved it? Second charge, how have you proved it?
regarding the marriage matter.
Bigamous marriage.
So far, I have perused the record yesterday, my lord. It is, first, if it
No. Second marriage, first affidavit, then there is a court certificate. What is that court certificate? Second marriage court certificate, what is it?
No, I have not produced here.
what is it?
It is a marriage and he has admitted that I have only one marriage.
Here. It's
Yes, there is.
not here.
He has admitted I only one wife, Brahmavati.
Sir, he said that he enclosed this certificate, but it is not in our record. Ma'am. And paragraph 34, my lord, the certificate of marriage shows is not. So I have felt that there is. Here, my lord. Is my lord.
Now come to the inquiry report. Second affidavit you have on the records,
Yes,
17/12/2013.
okay, my lord.
Just mark that. What is thereafter photocopy of stay order of Silchar Court?
Other side, not so.
Just show me that file.
Tolok to give. Tolok to video. To packing kore video.
So, Mr. Nutt, your marriage, both marriages are with affidavits. By way of affidavits.
This, my lord, mistake. I believe. Bola.
You can make a submission that when the relationship with the first lady was on, he was also having a parallel relationship with his present wife. That's all. It's
No, no, I'm-
Mr. Nutt, not very convinced.
My lord, the lordship may consider that it is a dismissal from service, whether it's a marriage to be proved.
The conduct of yours,
No,
dismissal is
my lord,
very,
my lord, before the charge should be proved. Whether I have second marriage to
well,
be
second marriage also, by
No, no.
applying your
Law-
standard,
law-
there is also no marriage.
proved. My lord, law is saying for
You make a submission that your second marriage is also an affidavit marriage, it's no marriage,
law.
then there can be no
My
bigamy. Make
I-
that submission, I'll
no,
consider.
my one thing is that I have given the judgment of the Supreme Court at the our High Court also.
Your
First-
second marriage is
No, no,
also
no.
not by
My
subsidy.
their charge is that it is, I have been penalized because from the dismissal from due to bigamy.
They have penalized you saying that you have a first wife, then you got married with another lady.
Yes, the bigamy to be proved.
Ma'am,
Yes, Lordship.
hear me. The facts here is your contention with regard to the first marriage is that it is only an affidavit marriage. There is no certificate. You have not denied the affidavit.
That is for the purpose of the marriage. My humble submission is that
Mr.
must have a
Nutt,
certificate.
Mr. Nutt, yet this we are considering only a disciplinary proceeding, not a criminal proceeding.
Yes, ma'am.
You have not denied the execution of the affidavit, have you? You have not dislodged that,
Yes.
right? So that affidavit with Nandavati,
Nandita Singh.
Nandita remains. Now there is another marriage with Prabhavati. This is also an affidavit.
I have not gone through this.
Premavati, this is also an
I
affidavit.
have
No other certificate is here. You have also not produced any certificate.
No.
Marriage is 1712, that is the execution of the affidavit. Both the affidavits,
In
you are
the,
satisfied, your wives are satisfied, they are your wives
my
by
lord,
way of an affidavit.
my humble submission of in the eye of law. In the eye of law, an affidavit marriage cannot be a relative marriage.
Then both the marriages.
Both the marriage null and void. Then how I
You
penalize?
say
Then-
that your second marriage is
Then-
the marriage.
No, that charge is how the bigamy charge is.
Oh, you are saying that I have only one wife, that
And
is
he
his
has
second wife.
stated in his
You have
statement.
married her by,
He has statement in the inquiry. He has stated my only his statement submission is that.
so that
but-
marriage is
but
also
if you're-
through a,
If you are I
affidavit.
have given the judgment to justify. First of all,
we'll consider.
if it is a bigamy,
Just give me the photocopies of the two affidavits. And the photocopy of the, what do you call that,
identity card.
identity card.
It is the same person, madam.
That he has admitted. My nickname is Devashish. That it is not a distinct.
Signature is-
I am not agreeing on. My only contention is that my law is saying that who held a marriage to be proved under section.
He was going towards the east
First of no.
very happily. Midway, he turned and started going west.
There must be marriage. to
Now
be established.
both east and west is on him.
My lord, bigamy, for the purpose of bigamy, my lord. Marriage to be proved. That is my submission.
The Lana Council for the parties. Any further judgments, anything you want
There's
to?
only one judgment, madam, or division with. Ma'am. Not for- Only. As per his plan advisement.
Good boy. Like these boys are rare now. And you are holding that against him. Very bad.
Both of the marriage, my lord, in the eye of law are not marriage.
So we will hold the both marriages to be the marriage.
Let him go. Oblige, my lord. Oblige.
But no, I'll pass the order on Monday. Hearing concluded. Registry to list this matter. I'm just putting it for further hearing,
My lord.
but no more hearing. I'll pass the order Monday. But top of the list, will I
The affidavit
give it to her. Affidavits and that certificate, that ID card. It is there in the records. You can take the records back. Mr. S.K. Medi, Learned Council, has produced the records. The same is written with, and it would be again furnished to the court on the next date of listing. Mr. Monto, what are you waiting for? 12.
10,
10.
10. 10, 10.
Huh.
Yes, so it's to be,
Those has to be that pay firemen's
yes.
fire rescue. Now,
Not
have you
firemen.
not been given the scale of the police personnel, equivalent scale?
No. We are not at par with the firemen, even they have lesser training than us. Requirement is
You are
lesser.
in the SDRF, you are there for all multi-purpose. schools.
Exactly, yes,
We
dear.
are science graduate.
We are science graduates and we had to
Where is
undergo,
who is appearing for the finance department?
Mr. Dhar has been shown, no? Which?
No,
Finance Gogoi.
Finance, Mr. Gogo is there.
their only case is that your case has not been recommended by the
Exactly.
pay commission.
I didn't say it is
Then
recommended.
what is the use of the anomaly committee,
Yeah.
that committee, this? I'll only ask one question, let's see what answer.
Exactly.
So, Monto, please wait for some time, let somebody come
Yes.
from the finance. You get somebody, Mr. Monto, Mr. Gogoi or someone.
Hello, this matter relating to allotment of land and subsequently cancel. Your lordship has may kindly come to page 16. Is the minutes of the SDLSC, whereby land has been allotted in favor of these two petitioners. Page 16.
Your allotment has converted into a settlement. Land has been settled with you. No. Huh? You have set up, you have taken possession of the land. No. And you are also in possession.
He is not in possession. We are in possession. That is
Huh.
false affidavit, lordship.
Your land is not the land which was allotted to Mr. Khan. Here. Your land is separate.
Boundary.
Separate land.
Both are separate.
Both are separate.
Both are same done. You
In
come
the-
to the,
Same land, lordship, after cancellation of the petitioner land, the same land has been allotted in favor of the,
that's it,
yes,
same land.
same land.
So how can he say that your land is in the boundary?
No, the school is existing in different land presently.
Okay,
School is existing in different
but
land,
different land.
different land.
This was
This
additional
land
land,
is
given.
adjacent land.
Adjacent land given to them.
Yes.
And what happened to that proposal giving the land to the respondent number 6? Government has, SLDC, it goes to the government? No, it goes to the government. After the SLDC, state level, district level committees report, it goes to the deputy commissioner. From the deputy commissioner, it will go to the government. Government will determine the premium.
Yes.
And thereafter,
That part has not come. Before that, lordship, the allotment was cancelled.
and the second subsequent approval of allotment with regard to respondent number 6 is also not processed.
No, because the interim order is operating. Page 22.
Okay, heard Mr. M. Khan, learned counsel for the petitioner, also heard Mr. N. Goswami, learned government advocate appearing for the state respondents, and Mr. Z. Hussain, learned counsel for the respondent number 6. Full stop. As agreed to by the learned counsel for the parties, registry to list this matter for hearing. For admission hearing, for hearing, no? Or admission,
No,
top of the list, for hearing on 8/1/2025, after vacation.
lordship, for further hearing, lordship can be.
Interim order passed earlier. Interim order is continuing.
Interim order is,
No need to extend.
lordship, can it be further hearing because your lordship has heard this matter on several occasions, lordship.
For further hearing. Show me. From where are you saying that statement? Why should I tell him? Why should he prove? You prove that he has land, he is not landless. How is petitioner number 1 and 2 related?
My lord, this same plot of land, lordship, 15 Lessa,
7.5, 7.5. How
Seven-
are they related? Are they related?
no, by the same Dag number, lordship, they, no,
They
no,
made
no,
an
no, no.
application
They are,
together.
they are not
How
related.
come they have been given in one allotment order?
One allotment order, that is, lordship, they are,
Only one allotment order.
otherwise they are not related to
Not
each other.
related.
No.
Both of them have land. He has some other land somewhere. Adjacent land. The Atlantic Council for the respond number 6 has submitted that both petition number 1 and petition number 2, both have land. One does not have. One is close to you. Two has some problem with it.
Thing is,
You file an affidavit to that effect.
police,
Hurry, you file an affidavit. Yes, Mr. Gusami, what can be done here?
On the basis of the psychological report, he has not had document structure. Report of the psychology is there.
Hmm.
Categorically stated, not land document. He has the possession, but he is not
What document will he have?
endless person.
Okay, he has not been able to demonstrate that he is a landless person. Yes, Mr.
Let before allotment of the land,
Some encouragement.
they have conducted an inquiry. I have annexed the inquiry report,
Where?
lordship, phase 11, your lordship. 12 is the vernacular. This inquiry was conducted on 26/10/2015.
Hmm.
A type copy, a translated copy, your lordship will find page 11.
What is your husband doing?
My lord, he's a lordship.
Okay. Okay. Cut it. Okay, that case, okay. Okay, got it. Now, Mr. I'm arguing. With reference to paragraph 2, I forgot. Paragraph 2,
Other applicant
I
has
was
any other
inside
land beyond
that
the land seeking.
departmental proceeding thing. Now I have come out. Yes.
Paragraph 2,
Paragraph 2, read that paragraph 2.
yes. Whether any, the applicant has any other land beyond the land seeking.
No, page 4, para 2 of your
Page
petition.
4. All on a sudden, after 2 months, another advisory committee meeting.
No, page 2, para 2, page 4.
Page 2,
Para 4, para 2, page 4.
page 4. That the petitioner originally resided in the village Sellakandi under then South Salmara Mankasar subdivision, now South Salmara Mankasar district created Swansea. Subsequently, the mighty river Brahmoder displaced the residents of the petitioner, and resultantly they become landless in the year 2005. Thereafter, they took shelter in various places in ordinary manner.
Now, what is the document to show that you were rendered landless because of river erosion? You had land, but you were rendered landless. Once that is there and you shift out, the concerned revenue authorities give you a certificate to that effect from Sellakandi.
There is lordship.
Where is that certificate? That you were in Sellakandi, you were a resident of Sellakandi, but because of the river erosion,
Well, so far,
you are a river eroded person. Where is that material?
so far residents of Sellakandi lordship, I can produce those document lordship.
No, that it was
But become
eroded.
landless, lordship. That authority lordship, they
That
to that effect-
authority has to give you a certificate. Otherwise, how will we believe that your statement?
No. They have conducted the inquiry lordship.
No, that conducted inquiry is only with regard to South Salmara, not with regard to Sellakandi. Come to that page 11.
Yes.
Now show me the documents you have enclosed against question number 3, from which they have drawn satisfaction.
My lord, so far this document.
And that is why the report has come from the circle officer that is there. I found it somewhere. Where is it, Mr. Goswami?
Without lordship giving any opportunity to the petitioner,
Fine.
That
But for that, if it
inquiry
is an
has
empty formality,
stated to be
Mr.
conducted.
Khan, if it is an empty formality giving you a notice, why notice? We will give you back everything. Establish what documents you had given along with that question number 3. Para 5, page 29, affidavit of respondent number 6. What is your reply to this?
My lord, para.
Para 5.
Yes, lordship, I have given reply, lordship.
Okay, had verified all requisite documents, including landless certificate and reports of so and so, so and so. Where are those documents? Just produce them.
My lord, these document,
That
lordship.
is your affidavit.
Yes, my lord, they have lordship submitted that copy, lordship, is.
Are they
Asked it-
verified all requisite documents, including landless certificate and reports of so and so, so and so, and being found in order allotment in their favor. Now show me where you have produced these documents. Where are those documents? And there was another affidavit by government.
Yes, the
No, two.
Yes, Mr. Khan.
my lord, as per land policy, lordship 1989, lordship, kindly see the requirement, what is to be placed, that is lordship. Page 70, 72, I think so. Only after allotment, requirement is that for settlement, page 70, lordship, allotment, settlement,
Page.
page 70.
Ah,
Allotment settlement of land for homestead purpose in rural areas, your lordship will say. The local indigenous families of the state who do not have homestead land in the name of any member of their families may be allotted suitable homestead land not exceeding 1 bigha per family. The land allotted for homestead purpose may be settled, your lordship, this is important, with the allotee after expiry of 3 years of allotment, provided the allotee is found to have occupied the land by constructing dwelling house and residence thereon.
that is different. That means they'll give you an allotment, they'll see whether you are still there. If you are still there, then your rights. But to give the allotment as a landless man, because you were not landless, you became landless in 2005.
My lord, we are landless because a river eroded people entire lordship
know
land
that.
has.
I know that. What I am trying to say is you were not landless till 2005 because in Selakandi you had land. Unfortunately, the river eroded that
Yes.
land. So rendered you neither here nor there. So you had to move out and seek some land to stay, survive. You came to this land. Now, what is the material to show that you were landless, rendered landless because of river erosion? Where is the river erosion affected people certificate? There is
It
a
is
certificate issued by the,
not, it is the authority lordship.
how
They
should
can-
the authority? You will have to take that certificate.
My lord, what happened, lordship?
Hmm.
At that time, lordship, they have, lordship, submitted the document. The lordship subsequently, lordship, one allotment landless certificate
was issued in favor of the petitioner number 1. Subsequent, Lordship, to the first
Issued by whom?
issued by the circle officer, Lordship.
Of which circle?
Same circle, Lordship.
How can he?
Mankasar Revenue.
How can he? Has he verified your circle details with the Selakandi village circle?
No, that is under, say, Mankasar Revenue Circle.
I know that. Circle officer would be different. Cannot be the same circle officer for Selakandi and your present place. Hatsing Mari.
My lord, there is no far distance, Lordship.
Far distance, same circle.
Same circle.
Can you show me? Establish that. That the place where you had land before land river erosion and the place where you are staying.
From my own experience, Lordship, I am from the same locality.
That's why I'm
Only
asking you.
1.5 kilometer, Lordship, distance. From Sellakandi to Hatsingimari.
Show me that.
Subsequently, again, I approached to the authority. This certificate, Lordship, has been
What about petition number 2?
petitioner number 2, Lordship. There.
Of village Hatsing Mari. You don't have land in Hatsing Mari. For that, we don't want this certificate. We know otherwise also.
Oh,
It says Hatsing Mari. You don't have village in Hatsing Mari. Village Hatsing Mari. Not Selakandi. That you had land in Selakandi and you were eroded.
oh, Sellakandi, they had the land. They had land.
So just show me something to that effect that you had land in Selakandi and you were residents there. Or I find your existence only in 2005 in Mankachar. Before that, I don't find you exist. And what about petition number 2? Such certificate could not be given to him because he has land, husband has land.
I have to obtain it.
Part heard. When? 15. 1/5.
1/5 of this month.
Ah.
Lordship.
Mr. Khan, Mr. Khan, learned counsel for the petitioner, after arguing the matter at some length, submits that he be granted a week's time to place on record materials to demonstrate that the petitioners were originally residents of Selakandi under the then South Salmara Manskachar subdivision and had come to the revenue village Bhimpara in the
Bhimapara.
year 2005 on their lands being eroded by river Brahmaputra. Mr. Khan shall place on record the documents which they had produced before the respondent authorities along with the respondent authorities in support of their claim for allotment of government land.
Already I filed an additional affidavit, Lordship. They have no any other document, Lordship. Already I filed affidavit.
To demonstrate that the petitioners were river eroded people. Also, the said instructions be filed in form of an affidavit on or before 15/12/2025, registry to list this matter again on 17/12 for further hearing. Just get me those details
Lordship.
and take this back. Etu DDR. Mr. Yeah, I see. He Gugu is good. Mr. Gugu is there? Yes, Mr. Goswami, you are appearing in item number 10.
Now the ball is in the court of to the Page 119, Lordship.
The finance is already rejected. Yes, Mr. Korpujari. Oh. You don't want to keep Mr. Monto waiting for. So Monto, you are here for some time?
Yes. Let me come. He was here, but suddenly probably called.
Yes.
We'll have it at 2 then, if not otherwise inconvenient to you.
Yes.
Don't seem to be well.
Well, this suffocated,
Ah,
this is very difficult.
we bear it every day.
It,
We are insulated people, not, we don't know what is going out in the outside world. Whether it is
So
cold,
long.
whether it is cold, whether it is hot, whether it is raining, whether it is sun, sitting inside, we don't know.
the thing comes to mind.
No, nothing. We don't know. Then somebody calls me and tells me that it is raining heavily,
Yes.
then only I come to know that it is raining heavily.
That we realized long time back when we went out of the room, that how there is a different world altogether outside. We were totally oblivious of that, inside only. That was,
Mr. Monto, please take some rest. We'll have it at 2 as the first item. তাৰপিছত dictation. Yes. Apuri. Sweet talking. Yes, madam. Anything more?
Classification.
Mr. Chaudhary, how can I help you? Tell me.
Then Lordship kindly allow me to submit a representation before the respondent number 1. He will consider a pass a.
I'll not do that. I'll only declare that you have if the age is in your favor and within that revenue village, any post of Anganwadi worker is available other than the vacancy, then your case would become. Give me 2 minutes, I'm coming back. 2013. So in addition to the eligibility, in addition to the educational as well as educational qualification mandated along with the length of service required, comma, a Anganwadi helper in terms of the guidelines, comma, to be eligible for promotion was required to be not above 45 years of age at the time of her consideration, of a case for such promotion. Also, the vacancy being available in the Anganwadi center, a vacancy being available against the post of Anganwadi worker in the Anganwadi center, the petitioner is presently discharging her duties, comma, the petitioner had approached the respondent authorities praying for consideration of a case for promotion against the said post of Anganwadi worker in terms of the guidelines contained in the notification dated 4/3/2013. Also, the case of the petitioner, however, was not considered for such promotion inasmuch as at the relevant point of time when the petitioner had made her such application, comma, she had already crossed the age of 45 years. Also, the respondent authorities thereafter issued the advertisement dated 27/5/2025 inviting applications for filling up of various posts of Anganwadi worker, comma, oblique Anganwadi helper in various Anganwadi centers functioning under the Matia Integrated Child Development Project, comma, including the post of Anganwadi worker lying vacant in 137 number Dolgoma Paulpara Anganwadi Center, comma, the center wherein the petitioner is presently working as Anganwadi helper. So, The said process of recruitment, direct recruitment having been initiated and the process being taken forward, the petitioner had instituted the present proceeding, present proceeding, praying for reliefs as noticed herein above. Push up. After the said advertisement was issued, it is to be noted that the advertisement dated that the applications invited, the last date fixed for submission of application in terms of the said advertisement dated 27/5/2025 was 6/6/2025. Also, thereafter, the competent authority had issued a communication inviting, scheduling the date of interview to be held in pursuance to the said advertisement dated 27/5/2025, on 18/6/2025. Full stop. When the said developments had taken place, the cabinet, in its meeting held on 7/8/2025, had adopted a had decided to increase the upper age limit of 45 years as prescribed in the provisions of the notification dated 4/3/2013 for consideration of the cases of eligible Anganwadi helpers to the post of Anganwadi worker. The enhancement was made up to the years of 50 years. So, in pursuance to the said decision of the cabinet, the respondent authorities issued a notification dated 22/8/2025, therein substituting the provisions of clause 6 of the notification dated 4/3/2013 to the following effect. Clause 6, page 40, tick to tick. Also, a perusal of the notification dated 22/8/2025 would bring to the forefront that the enhancement of the age limit prescribed for consideration of cases of eligible Anganwadi helpers to that of Anganwadi workers to 50 years has been so made with prospective effect. Also, the petitioner, in view of the said enhancement of the age limit, has brought into effect while the notification dated 22/8/2025 has staked a claim for consideration of a case for promotion against the vacant post of Anganwadi worker available at 137 number Dolgoma Paulpara Anganwadi Center. Also, this court has heard, I have heard the learned counsel for the parties, and also peruse the material available on record. The facts noticed herein above are not in dispute and accordingly are not reiterated. Also, the claim of the petitioner for being considered, the claim of the petitioner for being promoted to the post of Anganwadi worker existing, vacant post of Anganwadi worker existing in 137 number Dolgoma Paulpara AWC was not permissible to be considered at the time when she had so submitted her representation, inasmuch as at the relevant point of time the petitioner had crossed the age of 45 years prescribed for mandated for consideration for such promotion in terms of the provisions of clause 6 of the notification dated 4/3/2013. Also, as noticed herein above, the said post was put up for direct recruitment, and on the last date fixed for submission of the applications, also it is to be noted that the petitioner was not eligible for being considered for promotion to the post of Anganwadi worker inasmuch as she had crossed the upper age limit. Also, the said process of direct recruitment was thereafter taken forward and the selections were held in the matter. Any finality to that? Selections were held in the matter and the matter is pending. And the matter has not been taken to its logical conclusion. Full stop. The notification, the respondent authorities thereafter, in pursuance to a cabinet decision, had issued the notification dated 22/8/2025, substituting the provisions of clause 6 of the office of the notification dated 4/3/2013 and thereby enhancing the upper age limit for consideration of the case of a Anganwadi helper for promotion to the post of Anganwadi worker up to 50 years. The petitioner, in pursuance to the notification dated 22/8/2025, is found to be within the age limit now prescribed for promotion to the post of Anganwadi worker. However, the post of Anganwadi worker existing in 137 number Dolgoma Paulpara Anganwadi Center having already been put for direct recruitment for direct recruitment wide issuance of the advertisement dated 27/5/2025, this said post now cannot, it would not be permissible for this post court to direct for consideration of the case of the petitioner herein against the said post of Anganwadi worker. Further, from the advertisement dated 27/5/2025, it is found that the said post is reserved for candidates belonging to the scheduled caste community. Although the petitioner had raised an objection with regard to the reservation of the said post of Anganwadi worker for scheduled caste candidates on the ground that such a reservation was so made by the authorities without receiving the opinion of the people of the area who was covered by the Anganwadi Center, this court would not be in a position to accept such contention inasmuch as the reservation of posts is within the discretion of the respondent authorities and it has not been demonstrated in the present proceedings by the petitioner that the requisite parameters have not been complied with by the respondent authorities before proceeding to reserve the post of Anganwadi worker available at 137 number Dalgoma Paulpara AWC for direct recruitment for scheduled caste category candidates. Accordingly, the said contention would not of the Learning Council for the petitioner would not mandate any interference. So, in view of the conclusions drawn by this court herein above, the prayer of the petitioner for a direction for consideration of the claim of the petitioner for interference with the advertisement dated 27/5/2025 insofar as it has the effect of so far as the post of Anganwadi worker available at 137 number Dolgoma Paulpara Anganwadi Center would not mandate acceptance. Further, the prayer of the petitioner for a direction upon the respondent authorities for consideration of a case for promotion against the said post would, for the reasons cited above, also not mandate any interference. Also, the petitioner herein having been after the issuance of the notification dated 22/8/2025, raising the upper age limit to 50 years for consideration of the case of eligible Anganwadi helpers for promotion to the post of Anganwadi worker, the petitioner herein having been found to have been in continuous service for more than 10 years as an Anganwadi helper and within the age of 50 years, it is provided that in the event any further vacant post of Anganwadi workers arises within the rises in any Anganwadi center situated within the same revenue village wherein the present Anganwadi center of the petitioner is situated. The case of the petitioner be considered by the respondent authorities in terms of the guidelines as contained in the notification dated 4/3/2013. The petitioner is also at liberty to approach the respondent authorities by way of submitting a representation for consideration of a case for such promotion in the event any further vacancy is available other than the vacancy advertised while the advertisement dated 27/5/2025. With the above observations and directions, the present petition stands disposed of.
Obliged, Lordship.
Records are here.
Record here, madam. I'm led by Mr. King. Malak, he has made a prayer on 6.
Yes, what is your case?
Lord, my case is about the parameters on which they have made this decision, Lord, that do not fit in my case, Lord.
What are the parameters?
But they say that they have considered the entire service career of mine, Lord. But I am got.
There are 3 proceedings against you.
My Lord.
That's a bona fide consideration. Then there is one
Fair.
out
Out of 20.
That's the compulsory time, and what more is required? It's a it's not an objective satisfaction, mind you.
It's
It
a
is a
subjective.
subjective
but-
satisfaction. If these are there,
Right.
plethora of judgments of the Supreme Court that court keep your hands off. Anyway, Mr. Chaudhary wants an argument, adjournment will. A prayer is made on behalf of Mr. K. N. Chaudhary, Learned Senior Counsel, for an adjournment in the, Learned Senior Counsel appearing for the respondents, for an adjournment in the matter on the ground of personal inconvenience. Also, Mr. B.K. Singh, Mr. B.K. Singh, Counsel, appearing on behalf of Mr. K. N. Chaudhary, Learned Senior, appearing for the praise for an adjournment in the matter, the ground of personal inconvenience of the arguing counsel. Also, prayer is not objected to by Mr. Dubey. Learned Counsel for the petition. Also, accordingly, registry as agreed to by the Learned Councils, registry, Learned Counsel for the parties, registry to list this matter again on
6th of January.
6 will be too early. Just after the reopening. Give it after the Bihu vacation any day. Because that hangover will not go. You give.
I had one prayer, Lord. If my learned friend can permit the records, Lord, I can see.
You offer him a good cup of tea. If he agrees, I have nothing to say. If Mr. Thing is enough with a cup of tea, I have nothing to say.
My Lord, had restricted the zone. On that particular day, I will show him.
Cup of tea, Mr. Singh.
No,
Doesn't even want a cup of tea.
Doesn't even, Lord. Only the thing has been postponed, my Lord. Deeply obliged.
Show him, Vinod, if you can.
Yes, ma'am.
We will not force you.
Yes.
Yes, Ms. Chaudhary. See, when you come, Mr. Sahaiwala is also kept out by you. You're not allowing him to come to court. He's not there. You have stopped him. What is to be done? We'll have to hear both sides.
Yes, Lord.
After vacation.
Take it after vacation.
You have an interim order.
Yes,
Enjoy that for 1 hour.
sometime on 29th January.
Heard Ms. P. Chaudhary, Learned Counsel for the petitioner. None has appeared for the respondents. Accordingly, raised for the ends of justice, registered to list this matter after the ensuing winter vacations. Interim order passed earlier to continue till the next date of listing. That'll do, I suppose.
Lord, I prayed for some accommodation, my lord, fiction, my lord, any date, my lord,
Why?
for today, my lord, only.
You are arguing.
My lord, actually, my lord, also not prepared, my lord. He has left for some.
Okay. Who is appearing for the respondents? You are there. You are ready, ma'am. Why? Why this order is not being complied with in the manner required? See, the materials are here. You are ignoring to see it. The man was promoted on 21/2/2017. On that day, the merger had not taken place. And I find that in the line department, there is already a post of head assistant created for Santi Ranjan Pal. But he never came. That post could have been very well given to him. He has also not pointed that out. You have also not pointed that out. That a post is already created. No fresh creation is required. Only your name has to be substituted. As prayed for by the Learned Counsel for the parties, the matter stands adjourned. Registered to list this matter after the ensuing winter vacations on a date to be fixed by it. Okay. Yes.
Lordship, in this matter, department was supposed to file their affidavit.
No, they are not filing. You argue.
Yes, Lordship.
Lord.
Lordship, Mr.
So first day fixing. Today is the first day. Huh?
Lord,
Similar
they have
matter?
not filed affidavit yet, my lord.
Similar matter?
One is zero. Firstly,
Where? Okay, some other court.
My lord, may I,
What is that case?
My lord, in respect of the same issue, my lord, two persons were terminated. Once the petitioner before your lordship and by the other
Where is your termination order?
termination order at page termination order at page 52, my lord.
Till when was your contract subsisting?
My lord, contract
As on 25/2/24, the contract was subsisting.
Yes, my lord.
Until when?
My lord.
They say this order would not have come. It would have continued till when?
My lord. My lord, the agreement, as per the agreement, my lord, there was a renewal clause, my lord. And in terms of
that last renewal had taken place before 25/2/2024 when?
That
Okay. Miss B. Thapa, Learned Counsel appearing for the respondents, submits that she be granted further 3 weeks' time to file an affidavit on behalf of the respondents represented by her. Oh, sir. Registry to list this matter. Mr. D.P. Bora, Learned Counsel for the petitioner is present. Registry to list this matter after 4 weeks on a date to be fixed by. What did you?
Obliged, my lord.
Yes.
Yes.
It is Chandra Sharma.
Yes, lord.
Yes, where is the records? Okay.
Court has already submitted on earlier date, lordship.
To me, it was not submitted. I think I've given it. Records are there, madam. Okay, at 2 o'clock. We'll have it. He has already started. He's concluded also. We want your response in this one. Okay, okay, okay. The only thing is, there is a positive proposal from the department. The department has home and political department, especially the DGP and all, have underlined that they are required to be given a higher wages, considering the fact that they are doing odorous work. Now, the stand of the after the pay commission, the matter had gone before the anomaly. Anomaly committee was set up by you, by the government. What was the objective of anomaly?
It may arise. Terms of the recommendations the pay committee. Mandated.
So, if the anomaly committee makes a recommendation in favor of a particular issue raised by an employee, whether that issue will be considered by the government or it will go before again the next pay commission.
That's my lord. Pay commission. Pay commission make recommend. Rising of recommendations. Release are found. Permutations, combinations may be
Say
required.
somebody has a grievance that I should get 4,600, you have given me 4,200. We go up before the anomaly committee on examination finds. No, this is correct. No, Mr. Gogoi. Mr. Gogoi, with regard to this fire rescue people, matter is very narrow. They were not given any recommendation. I find that even the fire department as such was not considered by the pay commission. They had gone by the general thing, applying that 2.56 or 1.86, and they were given that scales, all. They were not compared. Earlier, there was a comparison parity with the police department. Somehow, it got lost. Now, they had a genuine grievance. Right, wrong. They went before the anomaly committee. Now, what I want to know from you is, no, I'm not on that. The anomaly committee is constituted by the government with some purpose. Anomaly committee is constituted by the government with some purpose. It has some sanctity there. So once, you need not just, once an anomaly committee considers an issue, employee, and answers in favor of the employee, not in this case, say a situation, says that no, they were given 4,600, they'll have to be given 5,200. That's the anomaly committee's recommendation, like we found in the education department. You accept that, the government accepts that, and then notifies. So that becomes an amendment to the 309 rules under which the ROP.
Subsequently, my lord, yes.
Now, further situation, what the anomaly committee does is, okay, you have come here, but we don't have the materials as such. So department, take a call, you give the justification to the authority. So it's basically a decision of the anomaly committee, but a little bit more exercise is directed to be carried out. Now, in this case, the department, which knows what is what, we presume that they made a recommendation in favor of the, I'll not say the petitioners, but the fire service personnel.
Yes, communicate.
They submitted a proposal. Now it comes before you as the finance department. I would understand you making a examination of that and rejecting it. Whether it is open to you to say that, no, we will not consider this, go before the pay commission. Next pay commission.
Is there, my lord, there is no big recommendation in
That is why the anomaly committee was there. That is why then why did you waste their time taking them to the anomaly committee? They would have been rescuing some other people there. Why this anomaly committee business?
171 part of the affidavit. The recommendation of the anomaly.
The anomaly fire suddenly moves. So they have given a very positive thing. So they say that appointing authority may examine their demand. So the appointing authority has examined their demand. Now, whether it is open to you to say that no, wait till the next.
My lord, so far as the recommendations are concerned, my lord, they are mere recommendations, not binding.
I'm not on that. I'm not on that.
Accepted
I'm
by
not
the-
on that, mister. The recommendations you take note of and by justifiable reasons, reject it. Nothing to say. But what is this rejection saying that, no, there was no recommendation? Then why did you go to before the anomaly committee? Why before the anomaly committee? That's the only reason we have to decide here. You take up the reasons given by the department. We are not coming in your way. You take a call. Okay, this is given, but see, these are the factors for which, because you have to not only consider the fire, you will have to take the effect on the resultant effect in all. That is different thing. But they have given some justification. On merits, reject it, allow it, accept it, whatever it is. But what is this form you are adopting? No, one line order, no. And these other officers, they have got no other job to do all this exercise in terms of the anomaly committee. Go up to the finance department and the finance department will say, no, there was no recommendation. Come before the next. I'm sorry, this is not acceptable.
Take a reason decision.
That we know what the conclusion would be.
And then, my lord,
We'll now decide it on. We'll say that this is not the manner. The finance department is not in a position to examine the issue. Given the issue, subject to what you satisfy us on merits, we are going to consider this on our own and we'll pass our direction. Come to.
proposals are there that starts from page subsequent to anomaly. Page 42 onwards.
A detail, I could go through a part of it. They have given justifications. Maybe not palatable to the finance department, but where is that rejection saying that you go before the, there was a note somewhere.
But that we have already annexed.
Hmm.
It is part of the affidavit that we have filed.
No, where do I find that that thing?
170. 8/8/19 it was.
175. As there is no specific recommendation of the 7th APP, so and so is not in a position to agree with the upgradation. So you only have said that because the pay commission had not said, that is why the subsequent action was taken. and it is not okay. If I require you to file an affidavit to indicate, state on oath, that the finance department has not concurred to any proposal for enhancement wherein the pay commission has not given. To file an affidavit to that effect, I'm dismissing the writ petition.
That, my lord,
That is your deputy secretary's view here. Come to 175.
I've seen it. Anyway, my lord, Lordship will see, my lord, the last pay commission, 2000. 10 years, my lord.
See,
that
they
was
have
the-
missed out 2010.
Hello.
They are now missing out 2016. So we'll have to tell them that you wait till 2026.
There was also, my lord, one thing, my lord. Whatever be the justification, my lord, furnished by the Home Department, fire department hearing. The Home Department. That part, my lord, of course, my lord, Lordship will direct, my lord, whatever be the issue, take a call, my lord, on the proposal and take a reasoned order, my lord. Reasoned decision may be taken. Maybe allowed or rejected is a separate issue.
But we know what is the outcome. They'll be just hanging.
We'll give a time frame, my lord.
That time frame would be a filing of maybe a larger size, a few pages added to this.
Fact, my lord, because, my lord,
But
this
I did not like, sorry, it may be the appropriate way for you to do it.
maybe not non-speaking order, but.
Non-speaking order, the ground. I'm now passing an order. You file an affidavit from your secretary that the state of Assam, the finance department has not approved any proposal for enhancement.
That
in
what
the
is
state-
already stated, my lord, the education department is.
That's what I'm
Uh-huh.
saying. I can give you examples of around 10, 12 instances of the 16 commission. 10 maybe more than that. So why this plea has been taken?
My lord, that.
This is not
representation-
called for. Because you shut off your mind. You've shut off your mind from the requirement of the anomaly committee. Easy way out, do it.
My lord, in that case, also will, my
Yes, Mr. Monto.
lord, some time, my lord, so that you can revisit the entire issue and take a call, my lord.
Well, they could have taken it while the matter was pending here, had there been some goodwill to do something for those who have been really deprived of. Now,
And Mr. Gogoi, why this anxiety? Because considering the service from where the persons are placed,
exactly,
only because of that. Because they are doing something more than what is expected from a person in a uniform. A uniform person does at a very higher grade than the civilians, but these people do it a notch higher. So that much value we should give them.
this is a demoralizing effect on the entire force.
We'll not allow that to happen, Mr. Monto.
That shouldn't be.
But I think
It is,
My lord, Lordship will give me one, son, my lord, so we can have the.
okay.
Whether they would like to revisit, but it may be reflected in the order so that I can continue. So far as the rejection.
During heard Mr. K.K. Monto, learned senior counsel, assisted by Mr. K.M. Monto, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned additional advocate general, appearing for the state respondent. During the course of the hearing of the matter, it was brought to the notice of this court that the proposal submitted by the by the Director General of Police,
yes.
by
Director
the
General of-
police authorities through the Home and Political Department with regard to the enhancement of the pay of the penal pay scale of the petitioners in pursuance to the directions, in pursuance to the observations made in this connection by the anomaly committee constituted in the matter, comma, on consideration came to be rejected by the finance department by a note dated 4/7/2022 by only stating that the finance bracket PRU department was not in a position to agree with the upgradation and and required the matter to be placed before the next pay commission. On a query made by this court, Mr. Gogoi has submitted that it cannot be categorically stated that in the state there was no enhancement made in respect of any service for which there was no original recommendation made for such enhancement by the pay commissions concerned. Mr. Gogoi submits that he would discuss, he would have his instructions from the finance department, from the authorities of the finance department as to whether they would reconsider the case of the proposal in respect of the respect of the employees serving under the Special Director, Fire and Emergency Services. Right? Special Director of Services in terms of the detailed proposal as submitted in the matter in pursuance to the observations made by the anomaly committee constituted after the in pursuance to the recommendations made by the 7th Assam Pay and Productivity Pay Commission. He submits that the matter, he would complete his instructions in the matter and prays that the matter be listed on.
One thing, my lord, pursuant to the recommendation subsequently made by the anomaly committee, whether my lordship has said, my lord,
No.
pay commission,
Anomaly committee constituted in pursuance to the recommendations made by the when?
immediately after the
Mr. Monto, when?
My lord,
after the vacation.
before
When?
vacation next week
Let him have his.
or Friday.
It is provided that the finance department, that the pendency of the present matter would not be a bar for the authorities of the finance department to recall, to revisit the proposal submitted in the matter, which was not agreed to be considered in terms of the note dated 4/7/2022 available at Annexure H to the affidavit filed by the respondent number 2 in the present proceedings.
On 20th of January.
On 20, raised as agreed to by the Learned Council for the parties, registry to list this matter again for hearing,
Further hearing.
On admission or hearing, it admission or hearing?
The admission.
For admissions on 20/201/2026. Let us see what happens now. Mr. Gogoi will use his good office. Mr. Gogoi, this things, just take it up. This is not.
Let us hope, my lord, otherwise it will be simply buying time as they have been doing earlier. I do not have any trust on them, my lord, frankly speaking. I do not trust these officers.
Mr. Monto, you are projecting the case. This is what feel I had when I was that side.
Exactly. No, there is a limit.
Finance was not very palatable department. But now, no.
They are
Now,
not,
after
they
having
cannot
come
behave
this side-
super
Mr.
government.
Monto, there is a reason why I'm saying. Now, after I have come this side, enhancement of a particular sector for the person concerned in that sector would seem that the government would have to pay hardly 10-50 lakhs or 1 crore, nothing. But for the government, the problem is once that sector enhancement is made, the tsunami is there in the other sectors. So that 1 crore goes up to a astronomical sum.
Well,
So that is why they are restrained.
well, maybe that may be their cause, but then my responsible submission is that could not be, or that should not have been the.
No. They should be a reasoned thing, a reasoned
Exactly.
order, so that we can consider.
Exactly, they should consider the things reasonably so that
Let
no
them
injustice
reject
is
it,
done.
let them allow it. Either way, they will have to give reason.
Exactly.
And that is what I want to consider. I don't want to consider saying a reason that you go before the commission, pay commission. It's very
True.
easy for me. I'll just interfere with it, send it back. But that will
I'm
not.
grateful, my lord, but then that will cause further injustice to them.
Let us see, Mr. Mondo. We are now season of the matter. Let us see.
Lordship may in that, Lordship has said that the Director General of Police, it is Additional Director General of Police come Director Fire and Emergency Services.
Under the Director, Fire and Emergency
Yes,
Service.
that is.
Mr. Gogoi, please see what can be.
Lordship has
Hopefully you give them a Bihu gift.
I'm grateful, my lord. So it will come as a
20.
part of that.
No, no, no. Kept it, let's see. This, or Saror আছে না? Etu শেষ কৰিলে admission kita. We'll just finish up the admissions and orders and then come back to you.
And those method is regulation, but
Decisions,
AK
Supreme Court decisions
yes, my here, Mr. AK Purkaisto is
on the prayer of Mr. And that is the only prayer I am seeing here.
my lord, that is why my lord,
Daily adjournment.
we have prepared yesterday, last night also I prepared, my lord. I can give this also, and otherwise we are in a hurry. But he saw that today's accommodation only it is
We will take it up. This is 24 matter. Heard Mr. M.J. Borwal, Learning Council for the petition. Also heard Mr. S.P. Chaudhary, Learning Council appearing for the respondent. University,
and I
Institute. To respond the respond number 2 to 5. Mr. Borwal submits that, prays that the matter be adjourned today on account of personal inconvenience of Mr.
medical ground, my lord.
Prays for an adjournment in the matter as the arguing counsel, Mr. A.K. Purkaisto, is indisposed. So, in view of the above and the same being the prayer on the last few, on the last dates of listing, on literally all the last dates of, on literally on the earlier dates of listing, this court directs the registry to accordingly admit the appeal, a writ petition for hearing. Registry to list this matter for hearing in its own usual course.
My lord, then, my lord, it will be harmful for them, my lord.
I can't help it.
Then, my lord,
Last 10-15 days,
I understand.
this is the only reason. Maybe it's true, but we can't. We have other matters to be concerned.
Then, my lord,
And every time
my lord, then, my lord, I will try, my lord. If
I'm sorry, order is passed. You go up on appeal.
My lord, in this case, Lordship, I pray for some accommodation, Lordship,
Why?
today. In this case, Mr. Senior Advocate, Mr. D. Das is leading me in this case. Today is unwell. He has left the court, Lordship. Government was directed to produce instruction, Lordship.
There are two writ petitions earlier filed.
Yes, Lordship.
Where are the orders? Yes, madam. What do you have to say? Madam, what is your grievance literally? I did not understand. That's why I'm asking.
Lordship, grievance, Lordship, last order, Lordship, page 78. It is the
78.
relevant portion, Lordship, page 80, Lordship. The direction was, Lordship, paragraph 7, Lordship, last paragraph. May I read, Lordship?
No, this is with this is with
Or
regard to a situation.
Yes.
This is a situation wherein
Yes,
a departmental proceeding was not instituted against you.
yes,
When this court passed this order,
Yes.
departmental proceeding was not instituted.
yes,
There were two complaints against you,
yes,
right?
yes,
Both these complaints were being considered separately.
yes,
So naturally you had a prejudice, you had a grievance. But
yes,
see, let it be in one place.
yes,
This court said, okay.
yes.
But after that, the situation has changed. You are placed under suspension.
Lordship,
Then there is a departmental proceeding drawn.
no,
What is the
Lordship,
error in page 82?
Lordship, my grievance is that, Lordship, before initiation of any departmental proceeding, it was internal inquiry. And court directed the authority, the district commissioner, to consolidate both the proceedings and directed,
Show me a law of the decision of this court or the Supreme Court that it is not open to the authorities to draw up a departmental proceeding against you under such circumstances, and it can only be drawn
Lordship,
after there is a preliminary inquiry.
Lordship, since Lordship court's order is there, Lordship specific
Court
order.
order is in a situation wherein there was no departmental proceeding against you. Now a departmental proceeding against
Before initiation of departmental proceeding, Lordship, they have not complied with
that
the,
law.
comply with the Lordship court order.
Show me that law, that it has to be.
Lordship,
When? Tomorrow? Day
Uh,
after?
he is suffering from Lordship today. He has left the court, Lordship.
When do you want it?
Lordship, after vacation?
Any interim order?
No, Lordship.
Madam, no interim order. Will not trouble madam in for the vacations, otherwise she'll have a headache in the vacation.
Lordship, there is a direction. They have to time bound.
You go ahead. If he comes, because we have not restrained you. Go ahead. On the prayer of the learned counsel for the petitioner, registry to list this matter again after the ensuing vacations on a date to be fixed by it. But this is a question which begs an answer.
Obligers.
Made please, Lord.
We'll only provide Mr. Barmia that your patta land they will not encumber. They will only limit the exercise only to the government lands.
Unauthorized cultivation, madam.
Unauthorized cultivation in the government lands.
In fact, they have carried out the Matadik.
So nothing is left.
We have filed an affidavit subsequently, my lord, showing while demolishing the unauthorized cultivation, as because the fields
You
were
go
not-
before that we cannot decide here. You go before the civil court, get your reliefs done. If they have done something like that, how can I, sitting in the writ court, do that? I don't have the evidence with me.
unknowingly,
And there is
knowingly
an
they have
interim
damaged
order
about.
passed permitting you to take the materials away.
So your lordship may be pleased to give a direction to consider our representation, my lord.
No. That you will have to go and establish before the civil court. I'll give you liberty. Withdraw this, I'll give you liberty. You go before the civil court, do whatever you want, whatever relief you claim. I'll say that they will do it in accordance with law. Because a very categorical statements in the affidavit of the government that we have
Our
put
land
red
is
flags
protected.
only in the government lands.
Our land is very much protected by the law, but while doing the damaging the cultivation of sort of
That
unauthorized.
is what I said.
or
The
actual
extent of your
also
damage,
done to
you
our
go
land.
and that is irrecoverable by you go and establish it in the before the trial court.
Civil court.
Civil
The fact is that my cultivation is over, last year's cultivation.
So that's
It has been
how
carried
can he
out.
today pass that direction, mister. Even if I pass that direction, that's why I was restraining myself. Even if I pass a direction for consideration of your representation,
Yeah, man.
what is the basis for that? How will the authority come to a conclusion? Nothing is there. There has to be some extraneous consideration either in your favor or against you. Either way.
Of
Okay.
course, by their
Heard Mr. M.H. Rajbharmiya, learned counsel for the petitioner, also heard Mr. J. Handy. You are for?
Lordship, government.
Government advocate appearing for the state respondents. Who's up?
Lordship,
As prayed for by the learned counsel for the parties, a registry to list this matter again after the ensuing winter vacations on a date to be fixed by it. Matter will not be treated as a parter and or tied up matter with. Before vacations, I'm not doing anything. After vacation. Because Mr.
Alright.
Bharmiya, you show me a way out, I'm with you.
Pujari was there.
For Pujari. For Pujari, for respondent. You find out a way for me.
On lot. We have already given lot.
No, you have given to many, but what about the petition?
It is under process.
Petitioner.
Other repeat also there, Lordship, at page 7, Lordship, the second, para 7, the
What more is required?
If they are,
We'll dispose it of giving them a time frame
yes,
to complete it.
yes, Lordship.
Because that plea that you have taken that this is not corrected in their case, in the earlier orders, will not be because that order is a order in rem. It's by their association. But Mr. P.P. Bhattakur, Learned Counsel for the petitioner, also heard Mr. D. Upamanyu, Learned Standing Counsel, Health and Family Welfare Department, appearing for the respondents number 2, 3, 4. Mr. R. Bapujari, Learned Counsel for, Mr. Who will appear for the finance? R. Bapujari, Learned Counsel, Learned Standing Counsel, Finance Department appears for the respondent number 5. The petitioner in the present proceeding has prayed for a direction upon the respondent authorities for authorizing to her daily her wages at the rate of rupees 900 per month since the date of her initial engagement as female attendant, na? Female attendant till
30/9/2010.
till
Page number 133, madam. Para 19.
till the date the petitioner was authorized her wages at the rate of rupees 900 by the respondent authorities. Because you were given that 900 subsequently,
Yes.
but you have not given the date. So, the petitioner in the above noted writ petition was engaged as a female attendant by order bearing a border dated 24/6/1980 at a fixed pay of rupees 50 per month under the scheme that was in operation at the relevant point of time. Also, the petitioner during the course of her service, the wages of the petitioner during the course of the service was enhanced initially to rupees 900 per month, and thereafter, with effect from October 2010, her such wages was being paid to her at the rate of rupees 3,000 per month till 2013, whereafter the petitioner and other female attendants came to be discharged from their services. The All Assam Health Centers Female Attendants Association had approached this court by way of instituting writ petition number WPC, writ petition being WPC number 900/2013, WPC number 1810/2013, and WPC number 4172/2014. Inter alia praying for authorization to the female attendants their wages at the rate of rupees 900 since the date of their respective engagements. The prayer for regularization was also there, along with other prayers as made in the writ petitions. Full stop. A coordinate bench of this court proceeded to hear the above noted writ petition filed by the association as well as other similar, along with other analogous writ petitions, along with others writ petitions instituted by similarly situated persons, analogously, and wide judgment and order dated 23/10/2017 disposed of the said writ petitions, inter alia directing the respondent authorities to pay the area honorarium to all the female attendants at the rate of rupees 900 per month with effect from their date of engagement till 30/9/2010. It is seen that in pursuance to the said judgment and order dated so and so, the respondent authorities had processed the matter and had released the honorarium in respect of similarly situated female health attendants who were members of the association so and so association. The petitioner herein, although being similarly situated, and the decision of the coordinate bench of this court rendered wide said judgment and order dated so and so being also applicable in her case, comma, the petitioner was not extended with similar benefit. Accordingly, the petitioner has approached this court by way of instituting the present proceeding. I've heard the learned counsel for the parties and also perused the materials available on record. It is not in dispute that the petitioner herein had served as a female attendant since, with effect from the date of her initial engagement, that is, with effect from the date of her joining in such capacity after issuance of the order dated 24/6/1980. The petitioner continued to discharge her duties and in course of her such duties, with a remuneration of, with a fixed pay of ₹50 per month. The fixed pay authorized to the petitioner was subsequently enhanced to that of ₹900 per month, and with effect from October 2010, the wages came to be enhanced to ₹3,000 till the date she was discharged from the said engagement. Also, Mr. U. D. Upamanyu, learned Standing Counsel, Health and Family Welfare Department, has, on the basis of instructions received by him, submitted that the petitioner herein would also be entitled to receive the arrears of her honorarium at the rate of ₹900 per month. 900 per month with effect from the date of her initial engagement in such capacity after due verification of her service particulars as well as the service rendered by her in the establishment where she was posted by the respondent authorities. Also, in view of the said submission and also noticing the decision of this coordinate bench of this court in WPC number so and so, and other analogous matter, judgment and order dated dash in WPC number so and other analogous matters, this court is of the considered view that the petitioner herein is entitled to receive her honorarium at the rate of ₹900 with effect from the date of her initial engagement as female health attendant. So accordingly, who will do that?
Lordship, it will have to be done from the director.
Accordingly, the Director of Health Services, bracketed Family Welfare, Assam, shall cause a verification of the service particulars of the petitioner. And in the event it is found that the petitioner was in continuous engagement since the date of her initial continuous service since the date of her initial engagement, which is projected to have occasioned in pursuance to the order dated 24/6/1980, the petitioner shall be released her honorarium at the rate of ₹900 with effect from the date of her such engagement till the time she was paid her honorarium at the enhanced rate of ₹900, and thereafter till the date she was paid her enhanced at the rate of ₹1 per month. Also, the said exercise be carried out by the respondents, by the respondent number 3, that is the Director of Health Services, bracket Family Welfare, Assam, within a period of 3 months? Because see, otherwise that financial year will go again, it will be hanging. In a period of 3 months from the date of receipt of a certified copy of this order along with a representation from the petitioner. Also, the petitioner is directed to submit a representation by disclosing the details of the services rendered by her and the salaries and the particulars of the honorarium drawn by her during such rendering of service by her. Such representation be furnished along with a certified copy of this order before the respondent number 3 within a period of 15 days from. With the above observations and directions, they provide. You give him a copy. Give him a copy. You keep it. Next time you want, you come back. This will be in the file. Who is going to do?
Obligors.
Please,
What is left here?
maybe drop lordship as per in terms of
Huh?
in terms of affidavit lordship, maybe drop lordship.
You want to withdraw, you withdraw it. Mr.
Yeah, Ahmed.
J. Ahmed, Learned Council for the.
They have filed affidavit lordship.
Fine. I'll not say it's complied with. If you want to withdraw, you withdraw.
No, lordship, no, lordship.
J.
I'd say drop lordship. Not withdraw lordship.
But J. Ahmed's Learned Council for the petitioner submits that the grievance of the directions passed by this court wide order dated 4/9/2021 in WPC number 5451/2020 has been complied by the petitioners in terms of the affidavit filed by them in the matter. Accordingly, he placed that he would not further press the present contempt petition. Also, prayer is not objected to by Mr. N.R. Sharma, Learned Council for the
On behalf of Mr. A.
Appearing on behalf of Mr. A.K. Bia does not dispute the said position. Also, accordingly, the present contempt petition stands closed. Accordingly, the order violation of which is alleged in the present writ petition having been complied with, the contempt petition stands closed. Next one also same. Only order date would be same.
Same lordship.
Same order.
Same 4921.
Item number 20, 22, 21, 22. Okay. Take a mic. 192, 2021, order dated 4/9/2020. 192, 2021.
May please your lordship. My lord, matter relates to, my lord, challenging the selection and appointment of
DPM.
DPS, my lord, district supporting staff, district technical supporting staff in the Kasar district. My lord, my client is saying that there are some other post. Obviously, my lord, contextual post. Some other posts are lying vacant, and the authority has assured that in the event of withdrawal of this case, he may be considered.
But if you want to withdraw, we can't say that we can't record all those things. If you want to withdraw, you withdraw. Otherwise, we have gone through. We are not entitled to even the preference marks because you have not cleared the written examination. Preference is in the interview only. So you were
Written examination.
under the contractor.
My lord.
Subsequently, you were continued with in the department for some time. And then they came up with the advertisement. Now the advertisement is taken to its logical conclusion.
My lord, we have allegation about the manner of conducting the written examination.
Sorry if that we will be.
And our other
Only an allegation is there is no material.
our other claim is that some area salary is pending.
Where is the prayer for that? There is no prayer.
Yes. My lord, it's page 18, lordship may kindly have a lower part. Direction to pay current and area remuneration. There are some area amount.
When were you,
April 2023,
when were you terminated?
my service has been discontinued after this election. Election list was published,
October 23.
my lord.
Yes, Mr. Goswami?
It was cleared, those.
Huh?
No,
When?
no, my area salary is there, my lord.
How do you say it is clear? Where is your statement to that effect, Mr.
My lord.
Sigda?
So, my lord, at page 817, paragraph 18, paragraph 21.
What is your reply to that?
They have not filed any affidavit, my lord.
They have not filed affidavit.
Lordship, in that count, Lordship,
If it is not paid, pay him. You want to withdraw?
My lord.
Mr. A.R. Sigda, learned counsel for the petitioner, submits that the recruitment for the post of DTSS, the District Technical Support Staff bracket DTSS bracket over, in pursuance to the advertisement dated, initiated by the advertisement dated 22/12/2023, has been taken to its logical conclusion. He submits that he on instruction submits that the petitioner desires not to press the present writ petition in order to explore other avenues of employment under the same employer. Mr. Sigda submits that he be permitted to withdraw the present writ petition with the liberty and also a direction to the respondent authorities to release his area salaries. Also, which is pending since April 2023. Also, order the linely taken to its logical conclusion. The services of the petitioner has since been discharged. Also, the above prayer made by Mr. Sigdar is not objected to by Mr. J.K. Goswami, learned additional senior government advocate appearing for the respondents. Also, accordingly, the present writ petition is dismissed on withdrawal with liberty as prayed for by the petition. It is provided that the dismissal of the present writ petition would not bar the respondents from considering the claim of the petitioner for release of areas of salary, if any due. The petitioner may prefer a representation before the respondent authorities for release of his area salaries, which shall be given its due consideration in accordance with.
My lord, may I be at liberty to approach this whole
With
court?
liberty, I
My
say.
lord. Deeply obliged.
That's why I have delineated this
My lord.
salary part. To get an employment, go ahead, try. Why not?
Lordship, as per office note, service is awaited, sir.
Service is not complete. It only went to Bishwa. But after
Is
that,
this-
what happened? It went to the branch office.
It went to the
Whether-
branch, it is delivered.
No,
as
no,
per-
it said Titan delivered Bishwa Biu. Beyond that, there is nothing. It should be delivered to the person, no?
Hmm.
The registry to put up a note with regard to the steps taken through usual process through the civil judge bracket junior division -1, comma, office of the district and session judge Dhubri. Registry to list this matter after 4 weeks along with the said note. Also, because usual process, what we happen, we'll see. If that is done with interim order passed earlier to continue till the next date of this. Obliged. Yes.
Lordship, the justice service, they have refused by respondent number 2, and we have filed the affidavit. And the office note dated 8/12 shows that the registered post, the service report is awaited, Lordship.
Trustee, they did not accept.
Lordship.
Registry to usual service, usual process. Through usual process through the civil judge, junior division, bracketed 1, -1, office of the district and session judge, Lokhimpur. Let's see. Because your case, there is some unauthorized transactions done, the account. That is what the problem is.
Obliged, Lordship.
Timing, madam. Yes, who is there? Yes, Mr. Nath. Mr. Kolta, for the time being, you take your seat.
Lodge.
Yes.
Please speak.
Then it was, just give me a few facts. Give me a few facts.
Please. Can you take up? The are there. Is there a number?
5 and 6 here.
5 and 6 here. But in therefore, cheapest part and on.
No, we have read it.
Finally, at page 7.
Mister, we'll go to that. We'll come to the legal tangles we have here. But before that, I want to know one thing. There was a selection. They have now mixed up two different Anganwadi centers, 2 different posts. It's a different thing altogether. Now, there is a merit list also. In the merit list, who is the serial number 1 and serial number 1 candidates? The petitioners or the private respondents?
That enquiry report.
I'm not on that. I'm not on that. I want who is the marks, highest marks, private respondents or the petitioners. We'll come to that. Inside, outside, we'll come to that. But as per the materials, who scored the highest marks? That is the petitioners. Materials are there.
That was before the end.
That this is 786 computer. It takes time to process. You all are that latest AI version. This is poor computer. Hold on, give it some time. Now, Mr. Nath, the it is an admitted position that the petitioners were, there were somebody above them also, but they were out because some, and the number one is you both.
Yes.
Now the advertisement says that they should be within the coverage area,
The survey area.
which they don't seem to be. But before you undertook this selection, the norms of the selection was changed. And it was said that it will be within the village. And they come within the village. No, that the government had subsequently modified. The government had modified and said that it will be the village, not the coverage area. No, after the advertisement, there is a notification. Where is that notification, Mr. Kulta?
Page 36, Lordship.
Page 36. Yes.
Cross to eligibility criteria, Lordship.
In this same village wherein the Angan. So, on the date when they were considered, it was these norms that were holding the bill. So, the norms that is there on the date of consideration, we hold it as a rule because this is an executive instruction. In absence of the rule, this will be the rule. So what is the error in their recommendation and appointment? Because Mr. Soikia's clients don't have the marks, but they are within the AWC coverage. Mr. Kolita has the marks, but he is within the village. It is covered by 1909-2009. Now tell me why this. That's all.
How difficult is the order of the honorable?
Now the matter is before us again.
Point them. How difficult?
We will clarify that.
We have to.
That happened because of your default. You did not come up before this court. Naturally, it happens with this court also. It will happen with any court that it waits for such a long time. Don't get a reply. And this is the consequence you got to face. And because of your default, these petitioners who were otherwise eligible are now hanging. And tomorrow, when we ask, if we ask Mr. Soikia to go, they'll also suffer because of you. So social welfare is not doing social welfare. It is doing diswelfare. The inquiry reports are both all shady. Because there was no other material available before this.
Yes.
That's true. I have.
We'll clarify that. We'll interfere with the appointments of the private respondents. Say that this was because of an error. And now the matter is before us. After review, we'll have to hear. And if you were so aggrieved, why was a review not filed in the earlier case also? Subsequent order is by my Lord Justice Buzarwala. Where is that? It's here somewhere I found. And that order had taken into consideration the earlier order also.
Yes. But even then, Honorable Court has said that you appoint. The difficulty is that there is a 2%. That is the difficulty we have. Even that is that difficult.
No, we'll clarify that. Yes, Mr. Soikia. That law has been changed immediately after the your what do you call? That was because you did not, by the time the appointment of the petitioners had occasion, you also did not bring it to the notice of this court. You could have brought it that they were appointed. You could have made them parties. You made a challenge. You did not make them parties. You gave an impression that this appointments have not taken. Government, inertia, sleeping. What can this poor court do other than direct? Where is that?
Page 52, Lodge.
That is it. Within the area of dissent.
Yes.
Right?
Yeah,
Debjani Gogoi is the only candidate within the area. Debjani Gogoi is
in the area of the center only.
Debjani Gogoi is not there.
We're not concerned.
We are not concerned with, we are concerned with 7.
We are concerned with Pegu and Rafi.
7 and 9.
Pulmai Pegu, it's the 7 and 9.
7 and 9.
Pulmai or Fulkumari, whatever it is. So this letter is only on the ground of insider outsider. Now there is another report. Now there is another meeting at page 59. Page 59, there is another CDPO's meeting. CDPO is there. Your earlier minutes is of 29/1/11. This is of 22/3/2012. And you come there. It has been said that she got the highest marks in terms of the government notification, 19/9. They are entitled and they have been given. This was not before the writ court. So, Mr. Nath, what to do?
About 75. Compliance with the
We'll have to interfere with this and the consequential appointments of Mr. Soike's claims, 5 and 6. And 19/9. 19/9 government memorandum which says that pass the orders.
CDPO. Here, the evidence.
That's it. That's it. Yes. Done. But Mr.
Because of they are
Anything else, Mr. Soike? But Mr. J. Kolita, Learned Counsel for the petitioner. So heard Mr. D. Nath, Learned Senior Government Advocate, appearing for the respondents number 1, 2, 3, 4, 5, 4 and 5. Mr. P. J. Soike, Learned 5. Now 6 is Gulabi.
Sorry, 5. Sorry.
1, 2, 3, 4, 5. Mr. P. J. Soike, Learned Counsel. So heard Mr. P. J. Soike, Learned Counsel, representing the respondents number 6 and 7. Also, before proceeding to also, the petitioners in the present proceeding have presented a challenge to the orders dated (16 to 2025) issued towards cancelling their respective engagements as Anganwadi helper and Anganwadi worker at Dokhin Utial AWC, AWC bile kuch mana Anganwadi Center day, and Bagdhora Anganwadi Center, AWC. Ito nilikhibi, patai khali kuch. Also, and a consequential appointment there against of the respondent number 6 and 7 respectively. Before proceeding to deal with the facts of the present writ petition, also, the facts leading to the institution of the present writ petition can be noticed as under. In pursuance to an advertisement dated 16/9/2099, inviting applications for appointment as Anganwadi worker and Anganwadi helper in various Anganwadi centers operating under the jurisdiction of the Child Development Project Officer. Which is that project here?
Tokuakna Child Development.
Under the Tokuakana ICDS project, including the post of Anganwadi helper in Dokhin Putial AWC and Anganwadi worker in Bagdhora AWC. Joyrampur Bagdhora AWC. No, please.
On 9. And the notification that's so in 19.
But on the date of the consideration, you can't go beyond this because this is modifying. The guidelines has been modified 31/8. Because it is the law that is holding the field on the date of consideration. Rajkumar. Advertisement has not said, I know, but the advertisement, the guidelines which will be, selection will be held, that was modified within 3 days before the last date of the application. Before that, then in superstition of all the selection of so-and-so is pleased to reconstitute. Modify the guidelines issued on 31/8/2009. So this 31/8 may have led to this 16/9. That has been modified. Bagdhora, Joyrampur, Bagdhora, AWC. Also, the petitioners as well as the respondent number 6, petitioner number 1, submitted her application for recruitment as Anganwadi helper in Dokhin Utial AWC along with the respondent number 6. Also, the petitioner number 2 submitted her application for recruitment as Anganwadi worker in Joyrampur Bagdhora AWC along with the respondent number 7 hearing. Also, on conclusion of the selection process, the respondent number 6 and 7, the petitioners although had scored the highest marks against their respective, against the posts for which they had submitted their respective applications, the authorities found the respondent number 6 and 7 to be eligible for such appointment by considering them to be residents within the coverage area of the Anganwadi center. However, a subsequent meeting of the selection committee was convened on 22/3/2012, and therein, basing on the marks scored by the candidates, a select list was prepared by adhering to the stipulations made by the government with regard to selection for the post of Anganwadi worker and Anganwadi helper, wide a notification dated 19/9/2009. So the petitioners herein having scored the highest marks and being residents of the village wherein the Anganwadi center was so situated, came to be included in the select list for appointment against the post they had submitted their respective applications. Accordingly, wide order dated 11/3/2000, wide orders dated 11/3/2013, the petitioner number 1 came to be appointed as Anganwadi worker in Joyrampur Bagdhora AWC, while the petition number 2, petition number 1 came to be appointed as Anganwadi helper in Dokhin Putial AWC. So the petitioners project that they had, in pursuance to the order dated 11/3/2013, assumed joined their services and were discharging their duties. At this stage, the respondents number 6 and 7, along with 1 Debojani Gogoi, instituted a writ petition being WPC number 2324/2013 before this court, inter alia praying for their appointment, praying for issuance of consequential orders of appointment as Anganwadi worker in their respective centers in terms of the decision. In terms of the inquiry report dated 29/1/2011. Also, a coordinate bench of this court, on noticing or after having accorded adjournments, after granting adjournments to the state respondents to bring on record their stand in the matter, such stand not having been brought on record, proceeded wide order dated 27/6/2013 to direct the respondent authorities to issue necessary consequential engagement orders in respect of the respondent number 6 and 7, herein in their respective Anganwadi centers. Also, the said directions passed by this court was complied with by the respondent authorities, and wide orders dated 16/2/2015, the appointment effected in respect of the petitioners herein came to be cancelled, Also, the petitioners accordingly instituted the present proceeding. The present writ petition was taken up for consideration by a coordinate bench of this court, and on such consideration, wide judgment and order dated 17/12/2011, the writ petition was allowed by interfering with the orders dated 16/2/2015, thereby reviving the earlier orders of appointment issued in respect of the petitioners herein. Also, the state respondents are now being faced with two directions passed by this court in the proceedings of writ petition number WPC, writ petition being WPC number 2324/2013, and in the present proceedings by judgment and order dated 17/12/2019, comma, instituted a review petition being review petition number
Review petition 136.
review petition number 136/2023. Also, a coordinate bench of this court, on considering the issues arising in the matter, was pleased by order dated 28/5/2025 to review the order dated judgment and order dated 17/12/2019 passed in the present writ petition. And the said judgment was recalled. Also, accordingly, the present writ petition was restored to file and listed for consideration. Also, as consented to by the learned counsel for the parties, the present writ petition is taken up for final consideration and disposal. আমি কালি 2টা বজাত লগাই দিম বাকীখিনি কালি দি দিম 2টা বজাত তুমি এইখিনি বেলেগ অৰ্ডাৰ শ্বিটত নামাত heard Mr. J. Kolita, Learned Counsel for the petition. Also heard Mr. Learned Government appearing for the state respondent, and Mr. P.J. Soikia, Learned Counsel, appearing for the 6 and 7. So hearing remains inconclusive, registered to for the hearing. You need not be here, I'll pass the orders. Let her type it down. Otherwise, if I have to correct the whole thing, it will take some time.
Obliged.
Okay, cool.
Here will also, my lord, they were asked to produce the record.
Yes, what is the ground, Mr.
Ground, my lord, the
Might have going.
interstate defects, my lord, so they have rejected mine. First, they decided to allot the work to me, my lord. Then it appears, my lord, they are also open my financial bid. But the condition in the tender document is, my lord, once the technical bid is rejected, then financial bid will not be, bids will not
They have
be.
opened your financial.
Yes, and found highest 36,70,000. And the person who has given now is 25
No,
lakhs.
why was your technical bid rejected?
Now they have given the ground, my lord, page 149. Page 149.
Look, with such soft looks, it gives me jitters. What?
I'm honest. It's not a sensible.
Mr. Sharma,
Yes.
he is having a big issue with regard to that the prayer of his is on public interest, saying it is Christmas
Christmas.
time.
But my lord, he never
Official
invites us.
shop
for-
like this should not be
No.
closed.
That is, no, that is all right. I accept that. But he never invites us in the Christmas or anywhere. So how can it? Anyway, if
That
he
is
wants,
fair.
my lord, I am not earning.
But Mr. Sharma is off.
So, my lord,
That we will not take the headache. We'll forget. Okay, what is the ground?
ground they have my lord rejected, your lordship kindly come to page 149. They have given why it was rejected.
149.
Yes.
Hmm.
These are the grounds given ultimately.
Ah, ha, 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 ha. Okay.
Not either to the instruction so, the envelope is not marked as hard copy of the technical bid. So that it will come within the minor.
You have to drop it in the box. Hard copy, you have to drop it in the box only. Yes, Mr. Huh. So if you don't write, it'll be some, it'll be. Is that a mandatory condition going to the root of the matter? Condition? Because this is just a formality. Your main thing is in the uploaded part. Uploaded, what is the problem? This is just a condition, additional condition. Right? The main thing is the online uploaded one. Everything is made on the basis of the uploaded one. I know that. The technical bid you consider is the one which is uploaded. That is what you consider.
When we go through the hard copy, Your Lordship.
Hard copy is for your satisfaction.
Yes. We go by the hard copy. Assuming this hard copy which they have not in. Saying is a hard copy of the tender bid. Even if we take that, okay, this can be waived off. What are the other conditions?
What are the other conditions?
CA certified,
Okay, where is the condition with regard to in your tender?
page 28,
28.
yes, clause 2.
Clause 2.2.
2.1. Is individual, a partnership firm, a limited partnership, or a company registered under Act 1996 enactments, who has proof of filing income tax returns of 3 the last row financial, duly certified by chartered accountant is eligible to participate in the bid.
Now, if I have submitted my returns in the portal, income tax portal,
Yes.
where is the requirement of a CA signature, PARDA CA signature?
That's the issue that
What was that? I remember.
they've held that the CA is mandatory.
Where is that order? It went up on appeal. What happened to the appeal?
Appeal is pending, but there is no stay in this order. Yeah, paragraph 30, Your Lordship.
Paragraph?
30, 184. The backdrop of the above. That the court interprets so and so the private respondent herein. Also is also a private respondent number, but income tax balance duly certified by a chartered accountant. Current counsel appearing here a person as well. Same has been held directly by technical bid committee. However, a cogent which extracted clause 2 and 6. So the requirement submission tax return as well as the balance sheets. Chartered accountant very eligible to the bid, participate in bid process. Court. Tender committee to state commission directory appears to be under committee. Technical respect.
Now, he did not give the income tax returns certified by by a CA,
CA.
or the balance sheet was not certified.
The
by-
both,
Both.
both they have to certify by CA. The income tax return as well as the
So
balance sheet.
now it is 1-1. One in his favor, one in your favor. Next one.
Next one. Mike, peruse this application, your lordship, page 61.
Now, what is the third ground? Not adhere to the instruction as illustrated at point 29 above. Point 29. Bank passport cancel sheet number 12. Yes, yes. What was the error here? Name is mismatch in bank details provided. What is the mismatch? A, Gatwar.
Ghatwar, this different, A.
And in the tender documents?
Tender documents,
Shankar.to. And your
Shankar Ghatwar.
Gatwar. And in the GHATWR bank?
In the bank, it's ER. ER.
Right, ER.
No, yeah.
Bank.
But why it is showing the printout one, they have E, otherwise
Okay,
PAN card, everything. Even the PAN card will also kindly come to page 73. 73.
Okay, next one.
Next one, sir.
By the point number 6. Point number 6 is.
No, well, where, yeah.
Relationship.
No. Point number 6 is different.
Relationship with any of the persons having any license, legal license or excise. There I have given the affidavit, my lord.
What is this point number 6, Annexure A of the bid document? Okay, that means that this one is Annexure C. What is Annexure A?
Annexure is at page, lordship, 61. Sorry, 59. This is the annexure is the application form. This is the
Okay.
application form.
Ah.
Point 17. The next page, page 61. Details of bidder relationship with any government servant or to any previous and or sitting excise license, he left it blank.
Now, will that be very, very?
It's a part of the tender clause. Here duly fill up the
We have
fill up the
given it by
application.
affidavit, my lord.
No, where is the affidavit?
Where is the affidavit?
Record them. Yes. Record.
He has not submitted income tax, sales tax and professional tax clearance certificate. Last one, not adhered to.
Affidavit, my lord, page
Oh, that
120.
is Momi, right?
This is Momi, your lordship.
124 is the affidavit.
Shankar Ghatwar is
So,
149.
that much only.
That much only.
4 points.
124 is the affidavit.
Yes,
But
Mr.
this affidavit they have to give. Even they have to fill up this form also, your lordship.
Both.
No.
Yes.
Not required. If you, it can be. Yeah.
It বহুত দৰকাৰী হ'ব because একটা মানে দুখন লাইসেন্স ল'ব নোৱাৰে একে নাথাকে।
Okay, Mr. Sharma, you can argue.
Yes. Now, my lord, this is there. Now, my lord, here, my lord, some of them are, my lord,
Mr. Bonig, your prayer is in the event we allow Mr. R.P. Sharma's case. Or if we dismiss Mr. R.P. Sharma's case, then what will happen?
Please. But I'm okay.
in any case, my lord, he wants to enjoy the Christmas.
Not at all for that. That's because I got it in a proper way with almost.
He started off by saying that it is in public interest. Okay,
Of course, public interest, our rules is private interest.
yes.
Yes.
What is your case?
Now, Mother, I have
Submissions.
explained in a petition also, Mother. Paragraph 10 of the petition.
I heard this matter sometime. I hear this matter.
Records were also.
And there is a clause 19.2 where minor defects can be waived, and particularly in keeping view, as per their own condition, Mother, that highest bidder will be given. And the government in that case, Mother, giving to the R8. R8 has not filed any available matter yet.
No, you make your submissions. What is your submissions?
My submission, Mother, there is no defect at all. Yes. And your lordship, I'll check the records also, original records from the government. There is no defect. Yes.
Financial.
Yes. And once the financial bid, once the financial bid is open, what was the intention? Otherwise, financial bid, there is clear condition in the tender document, Mother. Financial bid will not be opened unless a person qualifies in the technical bid. Yes. Okay, ma'am. 27.1.7 is the condition. What is the intention earlier in their part and what was the intention just turn around? Page number one.
Condition clause number
47.
30.
Page number 47. Page number 47, my lord.
Clause.
27.1.5. And also 7. 27.1.7. Financial bid of those bidders will be opened online who have qualified in technical bid. The bidder's name, so, total amount of each bid, and as such, other details is the tender bid committee may consider appropriate will be notified online by the tender bid committee at the time of bid opening. Once you open the financial bid, then means I was technically qualified.
How do you say that your bid was opened? Financial bid was opened?
Yes, because we'll go to page number.
Was it uploaded?
No, that is admitted in the my lord,
They
by
have
the
not
referee.
admitted.
Uploaded.
They have not admitted that.
Yes, 44. But I think in affidavit they have admitted.
No, they say that your financial bid was not there. That is
Yes.
why I
Lordship,
required
I'll
them
come
to
Page 144.
145.
Yes.
Tender management.
Tender bidding authority, office of the district commissioner, excise, Sonipur. Yes, this is mine. And second page, he is also uploaded mine. Second page is page 145. In the same format. 25 lakh, 10,000.
24.
Mine is 36 lakhs, 70,000.
Use for some code of. You can inform it.
Mr. This both are not the same.
Huh?
This is your uploading details. So this is the details as H1. This is the details you have uploaded. You have taken a printout. And this is the, after the tender, this
This is
this
official.
may be what is showing in the
It comes in a portal, your
portal.
lordship.
But here yours This is not the thing. This is the price schedule BUQ template. This is where you enter your price, not the price approved by the authorities. You have not opened his financial.
Because he was technically disqualified.
This is not the final consideration. Show us something so that we can give some jitters to Mr. Bonik. See to that his vacation is done with.
Yes, one more. I chose not to say my favor. Against it.
That is why he has Mr. R.P. Sharma to find out a way out of that whole situation. I'm just waiting for that one point. I'm not getting. Moment I get, I'm having you out. We'll have the public interest served through Mr. Sharma. Yes, Mr. So this is not the.
This, I'll get the instruction. Yes. Why on 18th?
After the.
But Mr. R.P. Sharma, Learning Council for the one. After having submitted, Mr. Sharma submits that it was his instructions that the petitioner's financial bid was opened. However, on a query raised by this court as to whether the documents at Annexure C would demonstrate that the financial bid submitted by the petitioner was open and the said document was only a pro forma of the bid, financial bid uploaded by the petitioner in the in the portal. Mr. Sharma submits that he would receive his instructions in the matter. Accordingly, he prays that the matter be listed on
18, my lord.
18. We can have it on 15 or 12.
This month.
12,
Let be 15, my lord.
15, 15, 12, 2024. Still 10 days are there.
Or not now for here only
15.
5 days.
Now from 15, there will be 10 days
To
for
Christmas.
25. You give us some handle so that we can
Yes.
at least save some people for some time.
There is one more case what I pay.
Obliged, Lordship.
Item 27, whether item 27. Hearing matter.
You have got the records?
Yes, Lordship, but Mr. Sharma is in leave, Lordship, since 4th December,
What
Lordship.
happened to him?
He went to the Delhi, Lordship, for medical treatment.
Oh.
He will be come back on 12th, Lordship.
12th of December.
Yes, 12th of December.
Our prayer is Mr. Sharma will have it after vacations.
I have the records, Lordship.
Miss, yes, Yasmin, Learned Council appearing for the respondent bank submits that the records, but records in original, huh?
Original, no, Lordship.
Records have been, records of the departmental proceeding instituted against the petitioner has been received by her. However, she submits that Mr. M. Sharma, the arguing counsel, is presently on leave, is presently receiving medical attention for the ailment suffered by him and is made for submission. Accordingly, she prays that the matter be taken up immediately after the ensuing winter vacations.
Can it be the 8th of January, my lord?
Mr. Sharma, Learned Senior Counsel, submits that but does not object to the prayer made. However, prays that the matter be directed to be listed on 8/1/2026. Also, accordingly, raised to list this matter again on 8/1/2026.
Highly obliged, Lordship.
Obliged.
Yes, madam. Pension rules. Records are here.
Yes, Lordship, on last occasion also,
Last occasion, why we did not see the records?
there was some submission from the petitioner side, Lordship.
What?
And Lordship also has noted that
in this.
he himself admitted that he did not join the
Oh,
duty and all
that's,
this.
I forgot that. Just let me. Forgot to make a note of that. When Mr. Gugoi is in between, there will be confusion. Where is the inquiry proceeding file?
Only the report has been provided,
No,
Lordship.
no.
There's nothing in this record, Lordship. Just take a statement and impose penalty upon me.
No, where did he make that? Where did you record that? He had that statement that he had admitted. Where was it recorded?
Lordship, then Lordship, can you take it up on Monday, Lordship?
Might be here, just. Where is your written statement?
Page 32, Lordship, my petition.
Page 32.
Yes. This type copy.
Lordship, this is page 33. The statement of the petitioner is there, Lordship.
32 is the type copy.
Okay.
This
That
is
is the
there, Lordship.
statement given before the.
Before the inquiry officer, Lordship.
What's wrong? There is no admission here, man.
Yes.
Now let us go back to the.
Lordship, this one. I was promoted as APO so-and-so and posted in the office of the DC Dhubri. I was released from so-and-so division on 29/6/2022, via order number so-and-so dated so-and-so. But I could not join as so-and-so at DC office Dhubri due to my health condition, which I informed the department by letter number so-and-so. Before that, I apply for review of my posting, posting order of so-and-so, the reply of which was not given to me. I frequently am a dealing assistant, but no reply was given to me. The regret, I was drawing salary of so till October 22, though I was released from so-and-so,
So
so-and-so.
where is that admission? There's no admission.
I have retired from service, so-and-so, promotion also. So he has stated, Lordship, I have not joined. This is the statement is there, Lordship. I have done.
That is with not, that is because of a reason.
I
that
could
my
not
health
join at
condition.
a spacing.
Mr. Counsel, please have a seat. That is because of his health condition. There is a reason given to that.
Lordship,
Now you prove that reason to be wrong, his thing goes.
Lordship, then this 2015 notification is there regarding any transfer of any government. They have first joined the place of posting, then they have to go for this, Lordship.
That is, where is your, that 2015 used here? Use it. I'm now concerned with the departmental proceeding, madam.
Departmental proceeding was, it was not immediately.
Mr. Sharma's, your client's stars are still not good. 415.
Yes.
That day I came to some conclusion, forgot. Now today I'll come again, I'll forget. Madam, you get me that records by Thursday.
Okay,
Otherwise I'll
Lordship.
forget that. Ms. MS Bhattacharjee has produced before this court the departmental proceeding records of the petition, departmental proceeding instituted against the petitioner. However, this court finds that the inquiry proceedings held in the matter by the inquiry officer is not part of the records. Ms. Bhattacharjee submits that she would produce the said records at 2 p.m. on Thursday. Raised it to
Please,
list this matter again on Thursday at 2 p.m.
Or on 12th, Lordship.
12th.
Yes, Lordship.
12th.
Next day.
12th, Friday. Okay,
Okay, Lordship.
12th. Good for me also. I'll have some time to file to pray. The records produced by Ms. Ms. Bhattacharjee is returned here. Just get me that.
Lordship, I understood.
And hopefully Friday, maybe as of Mr. Sharma, your client would be good.
Okay.
Only that much you show me.
Lordship.
Admission is there. I'm with you. Will not allow.
The time is over, my lord. So it's wrongly listed for hearing. Actually, the rule has not been issued. Your lordship may kindly fix it after vacation on 8th of January, if possible, for admission hearing.
Notice has not been issued.
Rule has not been issued.
Admitted for hearing on 26/4/2024.
26?
4/2024. Ms. M. Suikya, Lanak,
Never reached
counsel
my
appearing for the petitioner submits that the matter be taken up after the ensuing vacations. Prayer is
On
not
8th.
objected to by Mr. B.J. Talukda, learned senior counsel representing the state respondents. Accordingly, raised it to list this matter again. When?
On 8th of January,
Any problem? On 8/1/2025.
2019 matter, 2019 matter.
I'm having 14, 15 matters, ma'am.
Deeply.
12 also, ma'am.
Huh?
112 also.
Oblige, my lord.
Thank you.
Lordship, in 25 and 26, Mr. Roy has asked me to seek, because he's on legs. There's no hope for time being. This was a case, madam, the 25, madam, he was,
What about the subsequent penalty that has been given to you?
my lord.
I'm not going anywhere. I'm here only, Miss Monto. You can have a seat. I'm not going anywhere. I'm here only. You are in this case.
No.
Huh?
He's in
That
this.
26 will be called. Don't get excited. Huh? And why are you troubling Mr. Sharma so early? Ms. Monta, why are you troubling Mr. Sharma so early? He should be given leave. Yes, what about the subsequent penalty?
Subsequent penalty,
I didn't found.
So you're that charge against you, for which you were exonerated by this court on technicality, with the liberty to the authorities to go ahead with a further proceeding.
Further.
Now that further proceeding is there, established. So the period of suspension now will have to be determined how to be regularized by them,
My lords,
right?
my lords.
So if they say that it will be on duty, you get something. If not, then it will be having a different connotation.
Then that has to be, there'll be two periods. There'll be two periods. One period, I was kept away from work due to their conduct. That period goes. Regarding this matter, let them decide. If so, it will follow its natural consequences.
Dispose it off.
My lords,
Dispose of.
let's, Mr. Roy is not there. He has requested me.
On the prayer of Mr. D.
Roy, my lords, Mr. Roy.
D. Gugoi, who makes a prayer on behalf, learned counsel for the petitioner, who prays that the learned counsel for the respondent has requested in English. Prayer is made on behalf of Mr. S. Roy, SS Roy,
SS Roy.
learned CGC, for an adjournment in the matter. Prayer is vehemently not objected to by not objected to vehemently, not objected to by Mr. D. Gugoi, learned counsel for the petition, accordingly raised it to list this again after the ensuing winter vacations.
Right.
Yes, Mr. Das. Prabhakar Das. Yes, that records have come. Records have come. You can take those records, go and see through it and then bring it back. Because that literally has nothing, nobody to look after. Yes, Mr. When? Not before vacations.
After vacation, my lord.
Similar. Yes. Why? Not objected to by Mr. H.K. Das. Registry to list this matter on.
8, my lord.
Is that? Further hearing.
Further hearing. Oh,
22. 22.
but can it be on 20, my lord?
20.
Yes,
Okay, 20.
20.
Yes, Mr. Bhattakur, anything to say?
Much of
Okay.
May I please, your lordship? My last, in fact, lordship, this case was fixed at 2 p.m. on 2/12. According to matter listed, but your lordship
I forgot.
did not see it. That's
Why
why,
didn't you tell me?
my lord, only lordship short issue, without Shukas notice, without departmental proceeding, I have been dismissed.
Yes,
sir.
madam. What do you say? I wrote Ms. Bhattaji has to. I said Ms. Bhattaji, additional senior government advocate, to make a submission in the matter. Can you apply 311 to? Yes, Mr. Naik, additional AG.
On the last day, my friend was there. Apni asile to.
Mr. Naik, what is the purport of subclause B of the second proviso to 311, which says that you can reasonably not practicable to hold a inquiry, you can do something if you don't want. What is that? I don't understand.
Generally, we have.
No, that is C. That is C. Clause C. Or clause A, sorry. Clause A. B is not reasonably practicable. C is security of the country. Now, you don't issue a show cause notice. Thereafter, he is arrested in connection with a police case. Very heinous. Crime is heinous. But we are a country, we give Azmal also a fair hearing. So, when you come up with an order, no proceeding, no issue, notice, nothing. You come up with an order, that it's not practicable to hold the inquiry. He has committed a very heinous crime. He has committed a heinous crime. So, dismiss. The exemption is only to the extent of holding an inquiry. Where is the exemption from issuing a notice? Yes, Mr. Das, what do you say on this?
And apart from that.
And reasonably practicable to hold an inquiry would be that, say, he is there. He is so powerful, he will not allow the witnesses to come.
This case.
That inquiry officer is for the preliminary inquiry, not the disciplinary inquiry. And you see, read that further, read that line further. The girl's statement is under 183 BNSS. Right?
Yes, yes.
Something is there because I'm finding that these steps are being taken regularly now, especially in the police. We'll pass the order tomorrow. Tomorrow is Wednesday, Thursday. Pass the order on Thursday. First item.
Lordship. Perhaps this inquiry fiction.
No, that is conviction is
If there is a
constitution.
conviction,
Conviction subject to correction is A. Once there is a conviction, you need not have all these things. All this paraphernalia is not required. That is 10A. Services Manual. 311.
Yes.
Dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction on a criminal. That is A.
A.
B is where the authority empowered to dismiss so-and-so is satisfied for some reason. To be recorded by that authority in writing, it is not reasonably practicable to hold such inquiry, then 311 hearing is not required.
My lord, interestingly, that part is not there in the order. That
It's not there.
no, that it is not practicable to hold the inquiry. That
What
is
they
not
have
there.
done is, they have noticed the crime, offense committed, misconduct committed by him. Come to a conclusion that it is so heinous, we don't want him. That is not reasonably practical. Lekha. Mr. I'm not disposing it off. Just write down what is there. So I'll cut short my work also. Otherwise it gets pending. You address me on Thursday. Heard Mr. M. Khan, Learned Counsel for the petitioner. Also heard Mr. I'll put your name along with Madam. Mr. A. P. Nayak, Learned Additional Advocate General, along with Ms. M. Bhattacharjee, Learned Additional Senior Government Advocate, appearing for the respondents. The petitioner, by way of instituting the present writ petition, has assailed an order dated 14/10/2024 issued by the Superintendent of Police, Bongaigaon, Assam, towards dismissing the petitioner, towards imposing the penalty of dismissal from service upon the petitioner by invoking the provisions of Article 311, by invoking Clause B of the second proviso to Article 311 of the Constitution of India, read with Rule 10, bracketed 2 of the Assam Services Discipline and Appeal Rules 1964. So, the petitioner herein was appointed as a armed branch constable with effect from 23 to 2009, and was initially posted with the 16th AP bracketed IR Battalion, Bormonipur, Morigaon. So thereafter, the petitioner was transferred to the 25th Assam Police bracket ONGC bracket over Battalion, Digri Pukuri, Nazira, and thereafter was transferred and posted to the you are in the district police, Bongaigaon Police District Police Establishment. To the district police establishment, Bongaigaon. In the month of June 2022. Also, while serving in such capacity, the petitioner came to be arrested on 15/9/2024 in connection with Bongaigaon PS case number 318/2024 under section 331 bracketed 3/75 bracketed 2/127 bracketed 2 BNS 2023 read with section 10 of the POSCO Act. Also, the petitioner, the disciplinary authority of the petitioner on his being detained in connection with the above criminal case, proceeded to issue an order dated 19/9/2024, placing the petitioner under suspension with effect from 16/9/2024. Also, the petitioner was released from judicial was enlarged on bail by order dated
16/11/24.
16/11/2024 passed by the Learned Special Judge Bongaigaon. Also, it is also on being released from detention, the petitioner was served with a copy of the impugned order dated 14/10/2020, whereby in connection with the criminal allegation involved in the criminal case instituted against the petitioner, the disciplinary authority drew satisfaction that it was impracticable to hold an inquiry against the petitioner and proceeded to dismiss him from service by invoking the provisions of subsection of clause B of the second proviso to Article 311 of the Constitution of India, read with Rule 10 bracketed 2 of the Assam Services bracket Discipline and Appeal Rules 1964. Being aggrieved, the petitioner has instituted the present proceedings. Also, Mr. M. Khan, learned counsel for the petitioner, by drawing the attention of this court to the contentions made by the disciplinary authority of the petitioner in the order dated 14/10/2024, has submitted that the disciplinary authority had only considered the nature of the offense committed by the petitioner in the nature of the misconduct committed by the petitioner in the said order. So he submits that the provisions of subclause B of the subclause B to the second proviso of Article 311 mandates, empowers a disciplinary authority to dismiss, remove, or reduce in rank an employee without holding an inquiry by recording that it is not reasonably practicable to hold such inquiry. He submits that provision similar to the same, to the above, exists in the provisions of clause 10 bracketed Roman 2 of the said rules of 1964. He submits that the disciplinary authority in the impugned order dated 14/10/2024 has not adduced any reason to highlight as to why it was impracticable to hold an inquiry against the petitioner herein. He submits that it is sine qua non that for the purpose of invoking the provisions of Article 311 bracket 2-B, it is sine qua non that adequate reasons, the reasons have to be assigned by the disciplinary authority, preferably before arriving, before issuance of the impugn order of dismissal, removal, or reduction in rank, and or must incorporate such reasons in the order itself. Mr. Khan submits that although a notice in the matter is not called for to be issued before exercise of powers under Article 311 2-B, the assignment of reason for about with regard to the impracticability to hold an inquiry must find mention at least in the impugned order. So he submits that the respondent authorities had by selectively reading a order passed by this court in the case of Madhav Gogoi. Where do I find that? Madhav Gogoi. Madhav Gogoi, bracket, order dated, judgment dated 15/10/2020 in WPC number 4212/2020 had proceeded to pass the impugned order dated 14/10/2024. So he submits that the order dated 14/10/2024 on a mere having not satisfied the requirements of Article 311 bracket 2 subclause B, as well as Rule 10 bracketed 2 of the Assam Services of the rules of 1964. The satisfaction required to be drawn by the disciplinary authority before holding the petition before arriving at a conclusion that holding of an inquiry is impracticable, being absent in the order dated 14/10/2024, the said order would mandate an interference. He submits that the petitioner would be required to be reinstated in his service. What happened to the criminal case?
Criminal case, Lordship, is pending, Lordship.
He submits that the criminal proceedings basing on the same charge instituted against the petitioner is pending at the stage of charge sheet file. Stage of trial. Just confirm that to me.
Lordship.
But Mr. So-and-so. Huh? Mr. Nayak submits that he would make his submissions in the matter on 11,
11.
Just get it. Next. Thursday. No. Too much. Thursday we'll not take this because no, because I'll have to pass orders. We can't go beyond Monday. Till Monday I can accommodate. Monday. I'm sorry, that will not be possible. That will not be necessary because they have already filed an affidavit and they have said that this is the reason. So no need. Not like a Thursday. They have already filed an affidavit.
Yes, fine.
No need, Mr. Because if that is the reason, they have already filed an affidavit. There is nothing there. Oh, I forgot that. They have already filed an affidavit, and in the affidavit, there is nothing. There is nothing. They only referred to a High Court order and picked up selectively from there. I wanted to allow this on the last occasion only. Somehow time did not. But there is something legally to be done. Please address me on that.
Not as first item.
As first item. First item, like you make a mention, we'll upgrade it.
More
Subject to
Or
Mr.
2 p.m. Lordship, your Lordship can do. Or at 2 p.m.
2 p.m. No, morning. 7. 12 is the other matter. Yes.
One more matter. The item 30. Listener is not here.
It may be come up after vacation, my lord.
On the prayer of the Lanaka, it's a part of it.
And we have already-
Nine.
We have submitted our argument also, my lord.
Paucity of time, the matter could not be taken up due to paucity of time. Registry to list this matter again on 15.
15-12, my lord.
Because I forgot this. We only have to pass an order.
Only
A written argument already submitted, my lord.
One, দুটাই CAV কৰি দিয়া। Third the party settling judgment reserved. 1, 2. হ'ব? এইটো মাৰি কিনে কপি এটা বেলেগ দি দিলে মোক এইটো লৈ ল'ব দে। Thank you.